This ain't about who got mad. This about why they got mad. Cause every time the truth hit the room, somebody start acting a damn fool. M5K. M5K. Yeah. Old head posted up outside the liquor store. Said, little homie, let me tell you what I know for sure. You can throw facts in a room full of folks and watch one motherfucker damn near choke. Nobody called names, nobody drew lines, but somebody got offended by a general last line. See, that's the shit that always make me laugh. People tell on themselves and don't even do the math. A guilty conscience hear words a different way. That's why the wrong motherfucker got something to say. The truth ain't got to chase nobody down the block. Just drop it in the room and watch who get shot. Watch who get loud. Watch who get hot. Watch who start barking like they lost their mind. A hit dog gon' holler, everybody know. Truth hit hard when it cut too close. If the shit ain't yours, let it ride on by. But a guilty motherfucker gon' react every time. A hit dog gon' holler, that's the code in the streets. You ain't gotta point fingers, let the facts speak. Some folks learn, some folks get pissed, but the truth don't give a damn who it is. Teacher told the class, cheaters never win. Most kept working, one fool lost his shit then. Started explaining, started getting loud. Whole damn room looking confused in the crowd. Nobody accused him, nobody said his name, but somehow he volunteered and jumped in the game. That's how pride works, that's how ego moves. Some people hear wisdom, some people get rude. You can tell the room, stop hating on folks. Then one bitter ass person think it's a personal quote. The lesson ain't hidden, the lesson ain't small. When the truth hit a nerve, that nerve gon' call. A hit dog gon' holler, everybody know. Truth hit hard when it cut too close. If the shit ain't yours, let it ride on by. But a guilty motherfucker gon' react every time. A hit dog gon' holler, that's the code in the streets. You ain't gotta point fingers, let the facts speak. Some folks learn, some folks get pissed, but the truth don't give a damn who it is. Wise folks listen, fools start yelling. One take the lesson, the other get defensive as hell. One grows stronger, one stay stuck, one take accountability, the other blame everybody else and say fuck. Young blood, listen, this game ain't new. The loudest damn person usually tell on they self too. Strong people reflect, weak people attack. Strong people adjust, weak people talk smack. If a message ain't yours, keep it pushing, keep it cool. But if it make you explode, maybe that's the damn jewel. Cause growth hurt, healing stain. Accountability ain't everybody's thing. Some folks rather argue, cuss, fight, and complain than look in the mirror and admit they need to change. A hit dog gon' holler, everybody know. Truth hit different when it cut too close. You ain't gotta expose them, they expose they self. Every damn time the truth come off the shelf. A hit dog gon' holler, from the hood to the church, from the streets to the job, from the trap to the work. If it don't apply, let that shit ride. But a hit dog gon' holler every damn time. The cold part is, the truth never said a name. The guilty motherfucker did that part themselves. M5K. M5K.
Woo, how'd y'all like that intro?
Play to me.
What's going on, y'all? Welcome Welcome, welcome, welcome into the room. Welcome into the room, each and every last one of you wonderful people. I hope each and every last one of you is doing good. Let me go ahead and welcome my beautiful wife to the stage. What's going on, baby?
Hey, sexy.
How you doing today?
I'm doing good. I'm feeling empowered.
You feeling empowered?
And am.
What got you feeling so empowered, baby?
Because I'm on a hunt.
You on a hunt?
Yeah.
What you on a hunt for, baby?
Liberal tears.
Liberal tears?
Mhm.
You know what? Liberal tears, they go well with a little side dose of some good old fashioned truth cake. Because truth cake is delicious. You like some truth cake, baby?
I do. It's the yummy and delicious. Hey, Oniko.
Hey, what's going on, everybody in the chat? Salute to each and every last one of y'all. Yes. Please be sure to check out, like, share, subscribe, and support by hitting the Cash App, Venmo, PayPal, whichever one feels your wheels. Now, before we get started, baby, because I don't know if you heard the talk of the town recently, but when it comes down to the watermelon felon case, Mr. Karmelo Anthony himself, there has been an update. Did you hear about it?
A little bit. I was at work today, so I was a little lost.
Yeah. Once I got out of class, I went ahead and joined, our brother Izzy Band's show, and Izzy Bands is over there doing the show, and I got a little bit insight as to what was going on with this whole update. And shout out to brother Uda, because Uda was the one that was really bringing it. And I didn't know that Izzy tagged me in the show yesterday.
Shooter. Yes.
Yeah, Uda the blue shooter, the main shooter. Yeah, so Izzy tagged me in the show yesterday, and he was really coming from a narrative, not really a narrative, but from a perspective of, he tagged me, Angry Man, and it was two other people that he tagged, and he really wanted our perspective, really so much more so about the young brother by the name of Nolan Wales. Now, we are going to be doing a response in the stream to that. I just haven't had the time to really sit down and watch it. So, Izzy Bands, if you're watching, brother, I will be getting back to that content, checking it out, and I will be doing a response. But today, baby, in the watermelon felon case, yeah, I know. Hey, I love to drink my watermelon juice, and sometimes when you're drinking that watermelon juice, you turn your lips red. It's all right. Plus, I just got good lighting. It's okay. But what up, Nightish? How you doing? Appreciate you being here. Hey, Heidi. Heidi says, hi. It took me a minute to find the right thumbnail because you have two thumbnails that say upcoming and now two live. Yeah, it's StreamYard and YouTube is having a little bit of a skedaddle of what it is that they're going through. I don't know what's going on with StreamYard and YouTube. I wish they would get it fixed quickly, but I appreciate you finding the live and coming on in and enjoying your time while you're here. Now, with that being said, there's a few things we got to talk about. Baby, let me go ahead and show you this. Did you see this? So, recently, there was a little bit of an uptick and an update, right? So, I am sharing the right screen. All right, cool. So, recently, 12 hours ago, says that there was a order of referral on motion to recuse in Karmelo Anthony's case. There isn't much to read, but I thought you will all like to know. Judge Roach declined to recuse himself from Karmelo Anthony's case and opted to refer the motion to the district presiding judge. The defense is asking Judge John Roach to step aside from all post-trial proceedings, including the motion for new trial. I don't know why they believe that they're gonna get a new trial, baby. And the reasons is this: for his public comments after the trial, the judge gave media interviews and issued a public letter while post-trial matters were still pending. Baby, let's just deal with that right quick. Post-trial matters are still pending. Isn't that boy found guilty?
Yes.
So if he found guilty, everybody can give their comment on it, right?
Yes.
Oh, okay. All right. So let's deal with number 2. Comments about the verdict. The defense argues the judge publicly expressed support for the jury's guilty verdict and stated Mr. Anthony received a fair trial. Now, baby, from what you read about the trial, what you've heard, do you think Karmelo Anthony received a fair trial?
Yes.
All right. Next, it says defense of his own rulings. The motion argues the judge publicly defended decisions that are now being challenged in the motion for new trial. Okay. Appearance of impartiality. The defense contends these public statements could cause a reasonable person to question the judge's impartiality. And then courtroom access issues. The motion argues the judge publicly defended courtroom access and media restrictions that the defense claims violated Mr. Anthony's right to a public trial, specifically his Sixth Amendment. And then lastly, the gag order concerns. The defense argues that while others were restricted from commentating on the case, the judge later spoke publicly about it. So, baby, with that being said, really quick, what's your take so far?
This case is over with. It's over and it's done. And they're trying to get a redo.
They're trying to get another slice at the pie?
Yes. It's unclean hands.
Okay, all right. And then we also, baby, really quick, before we get into the actual document, we actually have the document from Judge Roach. It says the case number 296-835-62025, the state of Texas versus Karmelo Anthony, the order of referral on motion to recuse, a motion to recuse having been presented to me in the above styled and numbered cause, I respectfully decline to recuse myself and request the presiding judge of the First Administrative Judicial Region to assign a judge to hear the motion to recuse, all pursuant to the provisions of Rule 18A, Texas Rules of Civil Procedure. He signed this 2 days ago. In other words, baby, what is this judge saying in this?
Kiss my tail.
That's what he said. He said, kiss my tail. That's what he said. Okay. All right. Now, baby, before we get into this document, I do have to let y'all know there's a lot of reading to be done in this document, but we're only going to stick to the most important parts. That way we don't bore everybody. But with that being said, really quick, let me ask you this really quick, baby. From all of the social media content creation, mainstream media coverage that you have seen about this case, do you think people are just uncomfortable with the verdict because they don't like the way that the justice system is being ran? Or do you really think that people are just unaware, or rather not knowledgeable enough to really commentate on how it is that the justice system works?
Do you want my real truth?
Absolutely, yes.
I think a lot of people are racist.
Oh, okay. Well, talk your talk.
I think a lot of people do not spend enough time understanding due process. And because someone looks like them, they automatically jump to they didn't get a fair trial, this, that, and the third. When from what I heard earlier today, everything that happened in this trial is under the realm of normalcy. But because this is a little black boy, oh no, this is racism. You're being racist. He needs a fair trial. It is a fair trial. You have to actually purchase the damn the defense attorney that you need in your life.
Okay. All right. Now go ahead, baby. Go ahead. No, go ahead. I thought you was done. Go ahead.
No, I just think the friction in Allied is trying to talk to you in the chat, but I can't see them. I think the friction in regards to this is simply like it's untenable, because even when you show people what it is, well, no, because this, no, because this, because no, this, no, this. Like, no, just understand the law.
Okay. Do you think people are just sidestepping what the law or what perceptions they could have of the law because they really are just emotionally driven by their racist narrative? Is that what you're saying?
Yes.
Got you. Okay, cool. Heidel says ideological subversion groupthink. I like that. I really do like that. But I like the way my baby put it. It's racist. And a lot of people are just being racist. They don't like the fact that Karmelo Anthony has been found guilty of murder, and they're upset about it. But really quick, let's get to the reading of the motion. Now, To the honorable judge of said court comes now defendant Karmelo Sincere Anthony, by and through the undersigned counsel and pursuant to rules 21.1 through 21.9 of the Texas Rules of Appellate Procedure, moves the court to set aside the judgment of conviction and sentence and grant a new trial. This is weird to me, baby. Why do they keep asking for a new trial?
Because they think if it's in front of a new group of people that he's going to get linear penalties and a linear sentence. But my thing is, there's a lot of people watching this case. So, you sure?
Absolutely. Also, shout out to my brother Easy Bands is in the building. What's going on, Izzy? Appreciate you. He says he wasn't properly defended. That's just what it is. Appreciate you, big dog. And again, Izzy, I will be responding to your stream from yesterday. I just haven't had the time to sit through it.
It is what it is. Like, his attorney made some questionable decisions.
Mm-hmm.
But that's not on the criminal justice system. That's on his attorney.
Okay. All right. So the defendant moves for a new trial on 4 grounds. Now, it's 4 specific grounds that they are standing on. Now, in their pretty much their introduction, well, there's the pre-introduction, they list these grounds and then they list the reasons why. Now, again, like I said, this document is 193 pages. We're not about to read through all 193 pages because there is some exhibits that's put in here. But I think the most important thing that we have to focus on is those 4 things, those 4 grounds that they believe grants them of a new trial. But first, the court committed structural error when it materially restricted public access and violation of the right to a public trial. Now, let's deal with that for a second, because Brother Uda was talking about Waller v. Georgia, really, when we was on Izzy Band's stream. And baby, I know you wanted to dive into that, but I know you had some other things to do. But if possible, can you elaborate or expound upon that a little bit more? What's going on with the Waller v. Georgia thing, and why do you think it is that Uda brought that up, and why that doesn't stick?
For Waller v. Georgia, right, it was more so about wiretaps.
Mm-hmm.
The wiretaps were kind of suppressed. They weren't available to everybody. So yes, the suppression, that whole thing, it was reversed. This is true. But in Gnetco versus De Pascale, it was held, citing the controversy is not moot. This court's jurisdiction is not defeated. So it's more so about like the sensationalism of the trial. We saw what happened with the Diddy case. And shout out to Uda, because Uda was at the Diddy case. It was absolute pandemonium. It was ridiculous. It was ridiculous. And judges don't want to deal with the press circus. They don't want to deal with, their town having an influx of people that are just there to make content, because it's not like, the news, of course, would have came, but also the content creators being obnoxious, throwing baby oil all over the place, acting a fool, disrupting the lives of normal citizens that live there. They have a right to make the decision to minimize conflict. And when we're talking about a public trial, let's be honest, because I didn't get a chance to say this on Izzy Band's show. Even though Karmelo Anthony's side is upset about the limit of people that could be in the courthouse, the fact that press was allowed to be at court, the fact that there were people from both sides there in the gallery and in the audience, even if it was limited seating, it makes it a public trial. It wasn't private. So I don't think that that's going to stand.
Yeah. And then also on top of that, and like I said to Izzy Bands, and I was saying to Uda, I was really just expressing that, like Judge Rose has stated in his interview, he really wanted to protect the identity and the sanctity of these young children's testimony and who they are as a person. But I've played the clip before, and I don't want to play the clip again. But for those who want to hear it, I definitely can send it to you. But there was a video clip of two live streams, one of which they was threatening the young people who testified in the trial. They was threatening with doxing, they was threatening with harm, they was threatening with cyber stalking and regular stalking. They was threatening to find out their parents' jobs, which they did find out their parents' jobs. They was threatening to go to their homes. They was threatening to harass these young people that testified in this trial. And unfortunately, I don't want to participate in playing that audio again, because what was being said about those young children, I mean, they had their rights violated as well. I understand people want to think that, oh, well, they was just there because they was there to defend their friend Austin, and everyone's always trying to put Austin on trial and Hunter on trial as if they're the ones that is the murderers. Well, we know that Karmelo is the one that's the murderer because he's the one that's convicted guilty. He's serving 35 years. And then when it comes down to this whole thing about restricted public access, well, I think it needed to be restricted public access, because then you are dealing with young minors. But let me move on. The second is the state's repudiation of the parties' unrecorded evidentiary agreement. After the defense relied on it, coerced the waiver of Mr. Anthony's rights to testify and denied him a complete defense in violation of his constitutional rights. You want to speak to that right quick, baby?
They stated that he declined to testify.
Mm-hmm.
So this is also going to be another point of contention, because in the record is he's not testifying. He doesn't want to testify.
Right.
So if he said he didn't want to testify, his rights weren't denied to him. Now, according to what I heard on Real Spill with Izzy Mills, they had some backdoor agreement where he said he wasn't going to testify. And again, that speaks to the defense. That has nothing to do with the constitutional rights afforded to him under the criminal justice system. That was a legal defense strategy that was completely ineffective.
Correct.
Mm.
Yeah, it speaks volume, because now, I mean, like you said before, that doesn't fall on Judge Roach, nor does that fall on the prosecution. That falls on Mike Howard. And a lot of people keep saying he was railroaded, he was set up. If anything, his own defense attorney set him up. That's the way, I see it, because you're the one that agreed to this agreement. And if you didn't, like I was trying to express to Izzy Bands, you had at least 8 months with this young boy. You should have been preparing a defense for the whole entire time. But like you the one that discovered, and you the one that played the video where Mike Howard stated he was never there to defend Karmelo. Correct?
Correct.
Right. Ally says his lawyer left him for dead. Facts? Absolutely. So I find it crazy that he's filing an affidavit for a second trial when you're the one that failed your client. Anyway, third, the trial court improperly instructed the jury on the applicable law. How? They gave the jury instructions on how to apply or how to implicate the law when it comes to judging this case. But anyhow, I'm pretty sure we're going to get more into that. And then lastly, fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. I don't know if you had anything you wanted to say about those last two things, baby, or did you want to just go on?
Just go on.
All right, cool. So let's
actually, I do want to say something. First of all, justice has been upheld.
Okay.
Justice has been upheld. And in my humble opinion, if he gets a new trial, he's going to get more time.
Okay. All right.
He was pressed to decide whether he was still going to testify in only 10 minutes. But here's the thing. This is the thing that people don't understand about court. And I think a lot of people have never been through the criminal justice process or whatever. Mm-hmm. You're prepped to testify from the moment you start interacting with your attorney.
Absolutely.
Right? Because there were depositions done. So if you've already given a deposition and you've already been prepped, you're ready to testify.
Yep.
Whether it's 10 minutes or 10 seconds.
Yeah.
And the DA may have reneged on the agreement. That's fine. But that was closed quarter communications. That shouldn't even be a public matter. And as I stated on Izzy Band's show, the fact that his defense attorney is now telling the new team protected information between him and the DA, I wonder if he's going to get ethic violations for that.
Yeah, that's a big thing because you're speaking publicly about judges' chambers conversations. That's a big thing. But real quick, do I need to read this part? But once it adopted, the court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public. Well, yeah, I do need to read this. This case presents a structural public trial violation. Then why did you agree to it? The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial, it was required to make record-supported findings and to consider reasonable alternatives to closure. The court did neither. The access regime, oh Lord, limited public attendance to a narrow delay admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the three additional grounds set out in this motion, defendant asked the court to set aside the judgment and grant a new trial. So if they are requesting for them to set aside the judgment, they want Karmelo to be free or they want him to remain in jail. Because if you set aside the judgment, what are you going to do with this boy that's in prison? They asking for him to be back out again? Okay. And support the defendant shows the following. All right, the case and the verdict. This case arises from an altercation at a high school track meet. We know that. The defendant, Karmelo Anthony, was charged by indictment with the murder of Austin Metcalf. Okay. Alleged to have been committed on or about April 2nd, 2025 in Conner County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. Baby, did we hear that argued in court that he reasonably believed that?
No.
Oh, okay. All right.
We didn't even hear the defense attorney state that in opening or closing, but we did hear from the defense attorney's webpage that he was only there to provide reasonable doubt.
Right. It was never brought up that he reasonably believed anything because that wasn't what Mike Howard was there to bring up. But anyway, let's continue. The court's charge submitted the offense of murder of the lesser included offense of manslaughter and the law of self-defense, including the justified use of deadly force. The defendant did not testify. That's factually true. On June 9th, 2026, the jury found the defendant guilty of murder and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications and access logistics. In practice, public and media access were administered through that process. What follows is how that access was in fact administered before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Now, this is the part that I've found to be intriguing. Secrecy before the trial, the gag order, chambers conferences, and no public pre-trial hearing. The closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sua sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remain in force through the trial. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. The gag order's terms were sweeping. Unless first approved in writing by the court, no covered person could make any extrajudicial statement that addresses the character, credibility, expected testimony, guilt, guilt or innocence of any party or witness that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney, discipline, or other remedies. Its findings were 3 sentences: that media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. Baby, do you believe that to be true? Is this standard procedure?
Let me see.
Because I would only assume that for people.
Yeah.
Okay, so it's a standard procedure to have a gag order so that people involved in the trial won't be speaking out and potentially mess up the trial, which now would draw a mistrial or grounds for a mistrial. Would you agree or disagree?
I would agree. And also the children.
Mm-hmm.
Most of the witnesses, I won't say all, most of the people that testified were children. They were minors. And there was a lot of content creators that did worm their little nasty ways into the courthouse that told these children's names.
Mm-hmm.
Let's not also forget protecting the jury. These jurors now have potential threats against their life or whatever else. Why? Because people are upset that they made a decision based on what they saw.
Mm-hmm. Cold world.
Insanity.
Yeah, cold world. Let's continue. That alternative measures, venue change, jury screening, or sequestration would be inadequate alone, and that narrowly applied speech restrictions are necessary to protect jury impartiality. No evidence is recited. The order permitted only procedural announcements, hearing schedules, court filings, and statements required by legal or ethical duty. A safe harbor that proposed filings the public could see. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it until the completion of the trial. In the 10 months it operated, no person was ever alleged to have violated so far as the public record reflects. That's a lie. I hate to say this, but the example that he's given, that's a lie. We have a multitude of statements. We have a multitude of examples. There's literally Karmelo Anthony's father on TikTok talking about the trial. Do y'all not remember when I played that? You have a multitude of people who swore that they were witnesses coming out on live streams, posting videos, making community tab posts, doing YouTube shorts, talking about the trial, talking about what they perceive as evidence. Do you not remember that, baby?
Sure do.
So that's the reason for the gag order. You are speaking openly and publicly about a case which distinctively could drive impartiality within the jury. But let's continue to read this badly worded and badly positioned affidavit. The substantive pretrial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and on a May 29th, 2026 meeting addressing trial security and scheduling, occurred in chambers outside open court. Okay, so now they're going to be speaking about, what did you call them, baby? The judges' chambers conferences?
Yes.
Okay. No reporter's record of them exist. A matter the hearing will confirm. No pretrial hearing was ever held on the access restrictions, and the register of access reflects no such setting. The public docket discloses no motions in limine, that's funny, Because, baby, didn't you just talk about motions in limine?
Mm-hmm.
And none of the substantive pretrial litigation that in fact occurred. Filings that were hand-delivered rather than filed in the district court's public record. But you're talking about a backdoor, behind-the-scenes handshake deal in which y'all came to an understanding. But there was no record of it. At least from what I understand, there was no record of it. But yet you're complaining about evidence being hand-delivered and filings being hand-delivered. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. Baby, what you got on that really quick?
Why would you have to? If there was a meeting that they decided to have, and if it was off the books, right? This is something that is then on the defense attorney to be a whistleblower on. Because if it's not documented in the court of record, because they do have documents that are sealed in court cases, if it's not documented, whoever is making this assertion or this attestation, positing that this happened, better have documented, verifiable proof. And if the defense attorney did participate and allow this to happen without reporting this, then yes, he'll get a new trial for ineffective counsel, and the attorney will more likely than not be disbarred.
Yep.
So, and then that also brings another question. Had the young man gotten a lighter sentence, or had there not been this public outcry about the sentencing he received, would we know about this motion in limine? I just want to know real quick.
Yep. Really quick, I just want to speak on and play a little bit of evidence of something right quick. So I was saying to Izzy Bands on his show about how it is that Karmelo Anthony supporters were literally trying to cause a mistrial, and how it is that they were threatening the witnesses of this trial. Exhibit A.
Cover up. We're not only going to seal the jurors' names and the foreman's name, we're going to seal the minors, but you can't seal the minors' names because we were in court and we were taking notes, and we know who everyone is. And that is why at 6 o'clock, I'm going to expose every last witness that got on that stand and lied.
What?
I'm going to expose you. I'm going to put your big, ugly face up, and I'm going to talk about you like a damn dog. At 6 o'clock, join me.
So this lady at 6 o'clock on the day that this was posted, which, by the way, just to let you know, she did go live and she did put those pictures up of those minors, and she was talking shit and she was threatening them. But yes, by all means necessary, Karmelo was definitely given an unfair trial. But you have Karmelo Anthony supporters going out of their way, purposely attacking, doxing, and exposing the young witnesses, not only the young witnesses, but also the jury, but also the court-appointed staff. And she says she's going to just put their name out there, which she did, by the way. But yeah, Karmelo Anthony definitely had an unfair trial. Coolie Cat says she is wicked. Definitely wicked. Let's continue, because there was another piece that I wanted to play. I'm really trying to decide on whether or not I want to play this or not. I don't think I should. I don't think I should play that video with them listing off the kids' names. But then again, they do list the kids' names in this here affidavit. So maybe it might not be that bad. I don't know. I'll decide. I'll decide. All right. So the amended order, the written terms of access on May 18th, 2026. Yes, this is important. Now, there's a reason I wanted to play this. I wanted to talk about this. So, where is that TikTok of that girl? Because, there it is. Found it. Line backdoor manipulation. Is this it? Yep. Cool. So on May 18, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum. entered to govern all aspects of the trial proceedings. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell, found that unrestricted access or activity may compromise courtroom security, jury privacy, and the defendant's right to a fair trial. Well, per the video that I just played y'all, it sounded like that the court did the right thing, that the judge did the right thing. Would you agree, baby?
Yep.
So if the judge said, I want to protect these minors at all costs, and then you have Tiffany Billions and other people going out of their way to not just only dox, but also attack the minors and the people that was in the courtroom, specifically the witnesses, it sounds to me like the judge did the right thing and promised reasonable public access consistent with constitutional requirements. Now, there was a moment in time where at the high school where the stabbing took place, right? You do know that they granted access to the public to view that video, right?
Yep.
So what had happened was there was a TikTok live stream. This one specifically, hold on, let me pull this up. There was a TikTok live stream. In this TikTok live stream, which I will not play because it's going against the law. And the reason I say it's going against the law is because in this TikTok live stream, this young lady that you see right here, this young lady that you see right here, and this young lady that you see right here, they are discussing, or they're rather talking to and communicating with a young woman that worked at the damn Frisco ISD school department. And guess what she did? She live streamed the video of the stabbing last year. Regardless of what the Frisco ISD policies was, regardless of what the judge's order was, they live streamed the video last year. So again, I asked this question. When the judge says that he wants to impose rulings that would protect the community, protect the public from having impartiality problems when it comes to judging or ruling on this case, baby, I'm gonna ask you, is it okay for people to live stream evidence and then try to say, well, I did this for the betterment of the people? Is that fair enough to Karmelo Anthony? Will he get a fair trial? What's your opinion?
No. This is the thing. When people are sitting there and they're putting out information about a trial, what it does is it dilutes the jury pool. It dilutes the jury pool. It brings a whole bunch of looky-loos. It actually can bring potential violence to the courthouse if people feel the need to be retaliatory in nature during the case. So yes, the judge was well within the rights to protect the participants of this case. And again, if people are often thinking that judges are not aware of the matrix and social media interaction when it comes down to certain cases, but unfortunately, this was one that could not be ignored. There was a lot of people of color in particular talking about we all should delete Whitey. Like we saw people at the courthouse acting a damn donkey. What are we talking about?
Well, baby, I hate to do this, but I got to tell the truth. This is what we're talking about. This is the lady right here on the right here. This is the lady that works at the school department. And this is the live stream right here where she was publicly on TikTok live streaming inside Frisco ISD where you had to request to see the video. Let's listen.
Is somebody thinking somebody's live on YouTube? Somebody's video.
Keep listening.
Guys, I just dropped Adrian. Did y'all hear them people?
Yes, y'all heard what happened right there, right?
Yeah. Hey,
what happened?
They heard it. They said somebody's on the live and they got it on mute.
Somebody called in there and told them.
Yes.
Called in there and told them.
I dropped her.
Yeah, good deal. Good job.
Absolutely. What just happened?
Somebody
Nothing. We're all just joking around up here. Nothing happened. There's nothing serious. Keep it moving.
Somebody being a hater.
So hold on. Somebody called in and said that she was recording. It had to be something like that. Yeah.
They literally just said to her, somebody came in the room and said, "Hey, I just got a text from the receptionist. Somebody's got a live on you." You heard it too, right there?
Yeah, for sure. Yeah, 100%.
I immediately dropped her ass. And I would not.
Hey, look, she'll be fine. All she gotta say is like, "Oh man, my phone must have been still on. My fault."
So they're drawing up a narrative and lying, acting as if she didn't know it was okay to be live streaming evidence before it was presented to a jury. Go ahead, baby.
That's why she lost her job.
Absolutely.
But when we're talking about, protecting information, well, if you got people in the courthouse leaking stuff, yeah, it's the judge's job to ensure that justice is upheld. I don't really understand. I don't understand what the issue is.
Absolutely. Let me read this right quick. On July 16, 2025, several Public Information Act requesters were scheduled to review the footage under the supervision of Miss Michelle Aurelino. I don't know how to pronounce her name. I'm sorry. Executive assistant to the superintendent. During one such scheduled viewing, 2 requesters completed their check-in, were escorted outside the viewing area, and were asked to deposit their personal communication devices. Viewing instructions were then provided, and the viewers reviewed and signed their acknowledgement of the non-recording parameters required for viewing. While screening the video surveillance footage, the district administration's building's front desk receptionist received a call from a member of the public stating that someone was live streaming their video footage review. So in other words, they were in there live streaming the stabbing video when they was not supposed to be doing so. Hey, Beachy, they was attempting to cause a mistrial. Now, let me continue. The front desk receptionist then messaged Mrs. Arlino to inform her of the reported violation of video footage footage review protocols. Ms. Arlino then informed Dr. Waldrop, superintendent of schools, of the report. Dr. Waldrop entered the viewing room and asked if anyone present was recording. Both requesters denied recording because of the reported violation of security protocols, the Public Information Act. Requesters were asked to leave the building. Soon after, the district communications department learned that one of the viewers was live streaming from Kiyu Kandal Stadium. In the live stream, the Public Information Act requester could even be seen walking around K Stadium and pointing out where district attorney security cameras was, where they were mounted on the stadium structures. She further discussed that she knew where the cameras were located based on her review of the record. Later the same day, a Public Information Act requester was reported to be in a live stream discussing forum talking about her on-site review of the record. During the live stream discussion forum, the Public Information Act requester admitted to hiding a recording device in her pocket and continuing to record while viewing the video footage, despite being told by district staff that such recordings was not permitted. She stated that she planned to request to review the record again and would attempt to gather even more information than she was able to collect on July 16th. Through whatever means available. In other words, she was willing to break the law in support of Karmelo Anthony, which she already broke the law by live streaming the video prior to anybody seeing it. Baby, let me ask you a question. What does it show about Karmelo Anthony supporters when they go through such great lengths to break the law in support of a convicted murderer?
That they're very much unhinged, and they have lost the plot. Like, at the end of the day, you're willing to go to jail. You're willing to sit behind concrete walls and buzzers. I don't know what y'all think about jail. Jail is not fun. No, I have never been in jail, but I did work in a correctional facility. So when you, as an employee, are trying to get into work, you got to come to work a half hour early because you got to wait for the guards to buzz you in, honey. You got to put your purse in one place and your phone in one place. walk down these long halls, get buzzed in again to go somewhere. You deep in the Delta and you can't move how you want to move. So you mean to tell me y'all is willingly doing this, not for pay, just to sit there and go potty on a metal toilet and eat liquid eggs? I'm confused.
Extremely. Now, you said that's one person. You're right. That is one person. But let's continue. I have to solo myself out so y'all cannot see this video. But
it doesn't even matter if it's one person. Like, it's still an obstruction of justice. Those are federal charges.
Mm-hmm.
Yes, liquid eggs, Coolie Cat. What they do is they put the eggs in a big a kettle pot. And in the kettle pot, they put a whole bunch of water. Those bags are not whatchamacallit, sealed in, vacuum sealed. They not.
Yep. So Izzy said, y'all, that's just one person. Well, Izzy, here's the live stream from the young girl that I was telling you about. Friend Zone Neek, another woman who, by the way, if you look at her avatar right there in the upper right-hand corner, she was in that live stream where they were live streaming the video. Let's listen to what she had to say.
It's not Karmelo Detractors.
Okay. And here is my favorite witness. This is my favorite witness. My favorite witness.
Did you do PJ yet?
It was 10 people that was on the panel, but it was 1,700 people watching. After that live stream was over, it had over 45,000 views.
What the fuck? Yeah, I did. That was Paul. I said EP. I don't know why I said EP. It was because I said Espinoza, but that's PJ.
Oh, okay.
His name is not Espinoza, but I said that, but that was PJ.
Okay, got it.
Sorry. And I didn't want to. I was trying not to say his name because he a minor, but y'all know he full of shit anyway. Y'all know, but he was saying the same bullshit. He closer to Hunter than he was Austin and blah 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 blah. Okay, sorry. Here's my favorite witness. He said, his name is T. He goes to Memorial High. He plays football and track. He said that him and a couple of other dudes were there to put up the tents. He said it wasn't just Hunter or Austin that put them tents up. He said that Karmelo was there. He said he saw Austin.
All right, I'm gonna stop it right there because I don't want to play no more because she then gets to, after that statement, she then gets to saying some crazy stuff about what they're gonna do to the witnesses and what they're gonna do to the minors of the case. But yeah, Izzy Benz, I appreciate you, bro. You know it ain't no hate, but I just got to tell you, brother, this runs way deeper than what we see on the surface. But I don't want to make it about Izzy. I appreciate him. Yeah, go ahead, baby.
Yeah, but let's also talk about, because Izzy said, okay, it was 10 people. Let's talk about what they did to Sarah.
Yeah, Sarah Uncensored.
Yeah, so she has a whole lawsuit. She's already gotten judgment against Charleston White. She's also gotten clear to go ahead and bring action against Drew Anthony. What are we talking about? There was a lot of people, just because you guys are maybe haven't been following the case that closely to understand everything that was going on. There's a lot of stuff going on.
Well, it's having major effects. I mean, look at some of the things that's been going on in the content creation world. It was people, and I'm not saying this because I'm hurt about it, but it was people I was cool with. And because of my position and my stance on the Karmelo Anthony case, now all of a sudden I ain't shit. You have people out here, women and men, who are saying derogative and crazy out the way things against Black conservatives just because we said, what does the letter of the law say? Not, oh, we support Karmelo just because he's black, which I don't think you should support people just based on their race. Cooley Cat says, does this show that Karmelo supporters are the reflection of people that support killers just because of race and against white people, making them unreasonably evil? Yes.
Absolutely.
Without question. Without question. But let's continue because we got to get to this affidavit. Its operative terms were these. The courtroom will be open at 8:30 a.m. For the media at 8:40 a.m. For designated family members at 8:50 a.m. For the general public, no more than 9 members of the media would be admitted. Seating would be based on a space available basis. The doors will be closed promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess, and no one person who left could re-enter except at recess. All persons attending were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, or images related to the case or otherwise distracting or potentially prejudicial were banned. So to all of those content creators that went out there to the Karmelo Anthony trial and you wanted to go inside the courtroom and you were saying free Karmelo or touch me and find out or any other explicit statement or picture, that's why you were not led into the courtroom. It was not based on your race. It was based on the rules of the court. The order appointed Steve Stoller, identified any order only by a personal email address and cell phone number, as the court-appointed public information officer. Committed media credentialing to that office and announced that the court will not intervene or resolve disputes among members of the media regarding access or seating. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object any of it. Well, the problem is this is a trial that's including minors, and we're talking about minor witnesses. Anyway, the order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, sidewalks, green space, or any other designated area, under a nightly curfew from 11 p.m. to 6 a.m. Why would people need to be out there between 11 p.m. and 6 a.m.? This is not, what do they do at the Thanksgiving when everybody go to the stores and wait in line for hours?
Black Friday.
This is not Black Friday. You show up at the time you're supposed to be there, you get in and you leave. Anyway, beginning May 31st, 2026, it designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Under the order's enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space beside the courthouse before 6 a.m., exposed the violator to immediate removal from the courtroom, courthouse, or courthouse grounds, and the imposition of sanctions, including contempt of court, and no warning is required prior to enforcement. Again, if you've been warned and you've been told, then you just have to go. Simple. What's the problem? So, outside of these reasonings for people not being able to have access to the courtroom, based on the seating arrangements, based on the curfew, parking lot, and the pre-dawn line, this is one of the reasons that they demand a new trial. Baby, how do you think this stands?
I think this appeal is insane. It's insane. Like, what are they talking about? Like, listen, this is another issue that I have. All this legalese, my God, today. Where were y'all during the trial? Y'all are supporting this appeal for clout. Y'all are supporting this appeal for notoriety, and you're doing it for the free, no cap. So all of these great legal minds, where were you to support this young man if you feel that he's been, egregiously treated within the letter of the law during the court process when it would have been effective? I don't believe that this is going to be effective. I don't.
Yeah. I want to get to the next point that they was making because I don't want to read through all of the simple reasons why people weren't allowed to be in the room. It was given a rule and order as to who was allowed to be in the room. And I don't think that people being in the room or out the room is going to grant you a new trial. But anywho, the unrecorded agreement. This is the important part that I wanted to talk about. The defense tried its case under that limitation and reliance on an understanding reached off the record. So now we're talking publicly about off-record conversations. Great. The same off-the-record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May 2026, the lead prosecutor proposed that the parties try the case clean. So wait, hold on. So this happened a few months before the trial even started. That's June, February, March, April, May, June. So a month? 2 months? Okay. So I argue
for a year.
Go ahead, baby.
But they've been prepping for this case for a year.
They've been prepping for this case for a year, and they did not prep their witness or their client to potentially be on the stand. They didn't get their witnesses or expert witnesses in order. They were just going off the basis of, well, this just proves my theory even further. And it speaks to what Mike Howard said in his video. He never was prepared to defend Karmelo Anthony. He was prepared for the prosecution to mess up their case. But let's talk about what they talked about.
And remember, law. Let's just put us up real quick before we get back to this.
Sure.
Law is like a game of chess. There are no friends. The prosecutor is the ops. Yeah, I'm dumbing it down for everybody so everybody can understand what I'm saying. The prosecution is the op. The prosecution is trying to get checkmate in 3. So even if the prosecution say, yeah, let's do this clean, the defense attorney should have been prepared for the op to throw a curveball. And he should have had his rebuttals in order. You're trying to put my client in jail for the rest of his life for what he deems to be self-defense. It is not my job as a defense attorney to shake hands with you.
Exactly.
Unless what you're offering is a plea agreement to which my client is going to get the most beneficial outcomes. So if you believe that, I got a bridge to sell you in Brooklyn.
Big bridge too.
Let's continue.
Brooklyn Bridge is nice. Really quick, Bad Duck says, how can it be an unrecorded agreement if it's reported to the court? Good question. Now let's continue because this is where it gets juicy. Which, by the way, make sure that y'all are subscribing if y'all haven't already done so, and make sure y'all supporting the show. I know we ain't got no super chats over here, but you can hit the Cash App, Venmo, or PayPal. Now let's continue because this is where it gets important. The lead prosecutor proposed that the parties try the case clean. In other words, based only on what happened under the tent that day. Now, I'm going to ask you really quick, baby. You've read through everything that was reportedly stated in court. Prosecution, witnesses, witness testimony, teacher, police officer, medical examiner, coroner, and the defense was able to ask questions. Did the prosecution present anything outside of what happened under the tent that day? In your opinion?
In my opinion, they stayed to the facts.
All right. Now, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. Now, I want to make sure that I'm reading this correctly because I'm glad that Uda and Izzy were giving me a recap really quick before we went live. The lead prosecutor proposed this, that they only talk about what happened under the tent that day with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. Why did the defense attorney, Mike Howard, agree to this? Because if everyone is trying to base this case off of the Metcalf twins being bullies, why did the defense attorney agree to this? You can't talk about the Metcalf twins. They're not on trial. One of them is dead by the hands of the defendant, which is Karmelo Anthony. But he even threw in a little bit of sugar on top with a cherry. He said, we're not even going to talk about the defendant's character, his reputation, or extraneous conduct, evidence concerning him or anyone else. That sounds like a fair deal. But what was Mike Howard's position?
I can tell you what its position was.
Oh, really quick before you play it, Izzy Bands, appreciate you for the cash app. He says, I don't agree on this, but it's all love. Crazy. I appreciate you, big homie. Thank you very much. Play your video, baby.
It's only in a trial that both sides get to present evidence and cross-examine each other's witnesses. This is why our justice system is based on the principle of a full and fair trial. That's because it's only in a trial that the full story can be heard and that impartial justice can be done. We expect that when the full story is heard, the prosecution will not be able to rule out the reasonable doubt that Karmelo Anthony may have acted in self-defense.
I was going to say, why you say that? So did y'all hear that? Let me run it back for you a little bit. Now, knowing that he allegedly made this backdoor deal that's on the record, but off the record, but on the record, but off the record. What did he say?
Karmelo Anthony may have acted in self-defense. Be done. We expect that when the full story is heard, the prosecution will not be able to rule out the reasonable doubt that Karmelo Anthony may have acted in self-defense.
So his whole point was to prove that the prosecution cannot rule out that Karmelo Anthony did this as an act of self-defense, making a backdoor deal to what?
With neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant, Karmelo Anthony.
So let me understand this correctly.
Sure.
As a defense attorney, my job, per my statement, is to make sure the prosecution cannot prove beyond a reasonable doubt that my client acted in self-defense, and I'm going to agree to try the case clean without offering evidence of character, reputation, or extraneous conduct. But we all saw the video. So if the video evidence doesn't prove that the young man acted in self-defense, the only way to prove that would be his mentality, his mentation at the time of the incident, which would be predicated upon the previous extraneous conduct, character, and reputation of the Metcalf twins.
Say it again.
So where is the logic? The math is not mathing. It doesn't add up, but continue.
Okay, let's continue. The terms were negotiated in meetings and calls on May 5th, May 8th, and May 11th, and on May 21st of 2026. So y'all had 1, 2, 3, 4 conversations regarding this backdoor agreement. And you agreed to this. So you could have defended your client more than 4 times and you didn't. Okay. The parties presented the understanding to the court itself in chambers off the record. So why are you talking about this in an affidavit? You cannot be talking about judges' chambers conversations in an affidavit. You are setting the stage to make not only your client look bad, but you as a defense attorney look bad. The law firm that he either represents or that he owns or is partitioned to should be shamed. To avoid media reporting on bad act evidence, the understanding was memorialized only as a deliberately generic motion in limine, hand delivered to the court on the first day of trial. It does not appear on the public docket. I wonder why. Because it was a backdoor judge's chambers conversation. Why would it be presented in public docket? I know why. Or at least I think I know why. Because Mike Howard recognized I just made a bad deal. And I can't prove the fact that I made a bad deal unless people see the bad deal that I made. In other words, Mike fucked up. Would you agree?
Well, this is the thing. For those of you that never hired an attorney, the way attorneys' phones are set up, they automatically record because anytime they're having a conversation for their client, it's a billable hour, and they have to actually keep track of the billable hour for invoicing and compliance with the agencies that govern their business and their practice. So this is a problem. A problem. This is an ethical violation for what's his face? Mike Howard. If this is true, he has violated the ABA Model Rules of Professional Conduct.
Facts.
Rule 1.1, competence. A lawyer must provide competent representation, which requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Deliberately agreeing to withhold a full or best defense typically falls below this standard. Also, Rule 1.3, diligence. A lawyer shall act with reasonable diligence and promptness. The comments emphasizing acting with commitment and dedication to the interests of the clients and with zeal and advocacy upon the client's behalf. A lawyer should pursue the matter and take lawful and ethical measures to vindicate the client's cause, despite opposition or inconvenience. So, yeah, no, and a clean trial is not a formal legal term with a single definition. In context, it refers to a professional error-free proceeding. If it is used to mean the lawyer will intentionally pull punches or provide only minimal substandard defenses, that conflicts with the duties previously stated. Strategic decisions like choosing not to put on a defense case when the prosecution hasn't met its burden, or focusing on reasonable doubt rather than affirmative defenses, are often ethical and competent violations. He gonna get disbarred. He gonna get disbarred.
Absolutely. Really quick before I read Izzy's message. A motion in limine, because I didn't get a chance to explain what that was. A motion in limine is a pretrial motion that seeks the exclusion of specific evidence or arguments from being presented during a trial. A motion in limine is decided by the judge outside of the presence of the jury. The purpose of the motion of limine is to address potentially prejudicial, irrelevant, or inadmissible information that could unduly influence a jury or hinder the fair administration of justice. In other words, going by what he put in this affidavit, the prosecutor did not want to bring up Karmelo's past and try to influence the jury. That way, we can't bring up the hunter's past when we're talking about character, when we're talking about preconceived notions, when we're talking about all these other things. In other words, I only want to deal with the Karmelo Anthony that was under that tent. I'm not going to make any character statements. I'm not going to feed mainstream or social media to try to paint Karmelo as a villain or as a innocent person. I only want to deal with his actions under that tent. Put a 1 in the chat if you agree. And also, I'm also closing off the door because the defense is going to try to put Austin Metcalf, the dead victim, who was deleted by Karmelo Anthony. I'm not going to give way for y'all to not put him on trial as if he is the one who committed a crime. So I'm offering you, this is what I perceive he offered the defense. I won't go into Karmelo's past if you leave Austin and Hunter out of the equation. Let's not talk about his past. Let's not talk about their past. Let's only deal with what happened up under that tent. Baby, do you agree or disagree?
I disagree with that point, but I got more questions now because this is the thing, right? What are the implications? Like, this is potential ethic violations, disbarment risk.
Yes.
And due to the high profile nature, this could set a legal precedent. But in all actuality, this is really good for Karmelo Anthony. And I would have to now agree with Izzy and Uda that if this is true and it can be substantiated, he may get a new trial. But the onus would only be on Mike Howard. And I put in the chat, he is also now available for a malpractice lawsuit being held against him and his firm, and he would have to pay relief to the Anthony family. Now, my question is, does this taint the jury pool now? If he does get a new trial, does this taint the jury pool? Will the jury actually give a good verdict or give a fair verdict? Not even a good verdict, a fair verdict, because now they're going to feel like if there is a new trial, that the new team is just putting on to put on, they put 20 on 10, they're disturbing the dead, all of this and all of that. And what about the impact against Karmelo Anthony? Like, this is why, if this is true, I'm annoyed that Michael Howard, number one, can't hold water. Like, this is something you should take with you to the grave, because he's done. He's never going to practice law again if any of this is true. It's over.
Yeah.
Go ahead.
Let me continue reading, because there's another part that I need y'all to understand that is important in all of this. By filing a motion in limine, attorneys aim to prevent the opposing side from presenting evidence that could be highly emotional or legally problematic, thus avoiding any potential prejudice that could arise. Motions in limine are particularly valuable in cases where the mention of certain facts or information could taint the proceedings. In other words, Karmelo had epilepsy. Oh, and by the way, the Metcalf twins were hunters, and they wore camouflage and posed, and they took pictures of themselves of posing with guns, and where the potential harm caused by their introduction might be irreparable. Motions in limine are often used to limit or exclude expert testimony, like people who can say that Karmelo was in fear for his life because, I don't know, maybe because he had epilepsy, or that the Metcalf twins were athletes just like Karmelo and they practiced judo. I'm sorry, not judo, mixed martial arts. Such motions regarding expert witnesses are usually filed after the close of discovery, with a hearing on the motion in limine held prior to the trial. But Mike Howard agreed to a motion in limine type motion in limine type of proposal. He did not take his client, the Karmelo Anthony's best interest, into consideration. Now, let's get back to this. From that point forward, am I sharing the screen? I'm sorry. Yeah, I am sharing the screen.
Yeah.
From that point forward, the defense tried its case under that limitation at every stage in reliance on the bargain. And voir dire on June 3rd, the defense did not explore with the panel the themes of the descendant's character and aggression. it otherwise would have developed. In other words, without this agreement, they were going to bring about the Metcalf twins. Do you see how dangerous this is? That they were going to make the case about the Metcalf twins. Got it. In its opening on June 4th, it introduced none of them. Great. Through the state's case on June 4th, 5th, and 6th, the defense let the state's student witnesses leave the stand without confronting them with their own recorded statements to the police. That Austin Metcalf was kind of like the aggressive guy on the team, that he got triggered, that Austin and Hunter, they're not going to let you disrespect them, that if Austin is about to get into a fight, you can tell, and that he could be a bit aggressive at times, and an abundance of caution even narrowed the questioning the understanding permitted. The defense designated no experts, foregoing a neuropsychologist. Ain't that a bitch? How did I know this? I didn't even read this yet. Foregoing a neuropsychologist prepared to explain how the defendant's epilepsy affected his perception of threat, and a forensic psychologist prepared to address adolescent brain development. Ain't that a bitch? How do I know these things?
Child, listen.
And the fight or flight response, because the state took the position that such testimony would breach the understanding, because it would. So y'all can't talk about the witness testimony recorded to the police about the Metcalf twins. Let me highlight this. Y'all can't talk about the Metcalf twins because y'all now want to say that Austin and Hunter, rather more so Hunter, is the reason that Austin is dead, foregoing the fact that Karmelo is the reason that Austin is dead, minus the knife. If you minus the knife, Austin's still alive. Let's continue. The forbearance had a purpose. The payoff was to come in the defense's case, under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. The defendant would testify to the altercation like any other tent witness. I'm sorry. Let me make sure I understand this correctly. Under the understanding, as the prosecution itself repeatedly described it, covering all witnesses to what happened under the tent. So in other words, all of the questions that could be asked to the witnesses was what happened under the tent. Am I reading that correctly, baby?
Yes.
And then the defendant would testify to the altercation like any other tent witness, free of character impeachment, and the defense would present its self-defense case through him. So in other words, as long as y'all ask only the questions to the witnesses about that day, then we won't talk about, well, y'all would allow us to put Karmelo Anthony on the stand, and y'all would only question him to what happened that day. Am I reading that correctly?
Yes.
All right. Every preacher, I'm sorry. Thank you, Deborah, for the cash app. Appreciate you. Greatly appreciate it. Was there a message with it? I'm sorry. Hold up. 1 second, y'all. Nope, it was just an emoji. Thank you. Appreciate you, Deborah, for the cash app. Every pretrial discussion presupposed this. The prosecution repeatedly raised the ambiguous aggressor doctrine. I need to know what that is. All right. The ambiguous aggressor doctrine does not exist as a formal, recognized legal doctrine. Instead, The term is a colloquial or misstated phrase typically used to describe the initial aggressor doctrine or the dominant predominant aggressor law. The initial aggressor doctrine bears a defendant from claiming self-defense. The core details of these laws vary by jurisdiction. Let me look it up as for Texas. It's the law of mutual combat. Oh, ain't that crazy? 9.31 and 22.06. It's funny that we read that. Here's how Texas handles situations where it's unclear who started the fight or both parties consented. The initial aggressor bar. You cannot claim self-defense if you provoke the other. You cannot claim self-defense if you provoke the other person's use of unlawful force, unless you abandon the encounter, clearly communicated your intent to withdraw, and the other person kept attacking anyway. Why did the defense agree to this? If the threat is ambiguous, Texas evaluates whether your belief of being attacked was reasonable at the moment of the incident. If you are threatened by multiple people acting together, you are entitled to a self-defense instruction, even if some individuals in the group didn't explicitly strike the first blow. Mutual combat, consensual fighting under 22.06. If two adults knowingly and willingly agree to a fist fight, consent can serve as a legal defense to an assault charge. However, this is strictly limited. The fight must not result in serious bodily injury and no weapons can be involved. Well, there you go. You can't use it because a weapon was involved and someone died. Would you agree, baby?
Mm-hmm.
All right. Doctrine that matters only in a self-defense case built on such evidence. And as a trial counsel has sworn in this case, the defense would ordinarily depend on the defendant's own account of his perception of the threat. So why not put him on a stand? Let's continue. On Monday, June 8th, the final day of evidence, after defense had spent voir dire, how do you pronounce that? I'm not French. It's opening the entire cross-examination of the state's
voir dire.
Voir dire. Thank you, baby. It's opening the entire cross-examination of the state's case and the first day of its own case, honoring the bargain. The lead prosecutor announced that the agreement had never contemplated a testifying defendant and asserted that defense counsel had already opened the door by mentioning and opening that the defendants played chess, a position the court itself rejected. Okay, so this is the part that Uda and Izzy was telling me about. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding, an understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record. In other words, Judge Roach upheld to the agreement, but y'all the ones that brought it out. Rather, the prosecution is the one that brought it out. But the defense went into that. 1 second. I want to play something right quick. And I was trying to explain this over in Izzy's show. Here it is right here. So this is important because you had quite a few people that was over there in Izzy's chat like, you don't know what the hell you talk about, two different cases. Well, here's what happens naturally in the case when someone goes into something that they're not supposed to go into.
Protect property, correct?
Yes.
Property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
Now, that statement right there came after Kyle Rittenhouse's arrest and after he was bonded out where he participated in a show. and he made that statement. The prosecution is now trying to go into that and use it against him. Listen.
Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
come on,
Finger. First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
Oh,
keep watching because it gets good.
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
Their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you without any advance notice to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect.
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Now, this is why, Izzy, this is why I brought it up on your show. Mike Howard, baby, is Mike Howard not an expensive, is he not a good lawyer? That's what everybody's been saying about him, right?
Yep.
Everybody's been saying that he's experienced. So why would you bring up that he is a chess player? You can't talk about his character. And if anything, Judge Roach should have responded the way that Judge Schroeder did. What the hell are you doing? You're an experienced lawyer. You know you can't go into this. And to everybody that was in Izzy's chat saying shit, I'm not attacking your chat, Izzy. I'm just attacking the ones that was talking shit. I know what the hell I'm talking about. You're not supposed to go into if anything, if the defense wanted to bring up anything about Karmelo Anthony's character, him being a chess player, or anything else, he should have went to the judge and got permission first. Am I displaying that correctly, baby?
Yeah.
Okay, cool. Now, I don't want to spend too much time more on this because this is like 15 minutes long with him chewing out this prosecutor. And he told him, you're literally teetering the lines of violating his rights. He warned this prosecutor, I can throw you in jail for doing this. And I can fine you I would take your license for doing this. And you know this. So why did an experienced lawyer like Mike Howard do what he did and bring up character witness? Well, I stand of the position that Mike Howard is attempting from the get-go. he wants to produce a mistrial, or he never planned to defend Karmelo, and that he wanted a retrial. I still stand by that. And per the video that my baby played earlier, Mike Howard said he never planned to defend him. Bingo.
So he planned to get $75,000 from this family, fleece them, set it up for a retrial. Like, I don't really want to do this, but I'm gonna take this money, and now he's gonna have to pay millions of. Well, he's gonna have to probably pay a substantial malpractice claim.
Absolutely. Let's continue. And that if the defendant testified, the door to character and extraneous offense evidence would almost certainly open. Allotted 10 minutes, the defendant elected not to testify. So in other words, Karmelo chose not to testify. So now we know why Karmelo didn't go on the witness stand. Because Karmelo said, I don't want to go up there.
But I thought they agreed to try it clean. No, they agreed to try it clean, right? According to this document. If it's either he decided not to go up there, which is what was reported, or they didn't try it clean at all. He just said he ain't want to do it. This is going to be a very interesting dissent to read.
Absolutely. Allotted 10 minutes, the defendant elected not to testify. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witnesses. And at punishment, the defense's case was reduced to 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment for witnesses and offered none of the extraneous offense or character evidence cataloged in its 75-page notice, resting its punishment case immediately, exactly as the lead prosecutor had described on May 11th, that the agreement would operate. So in other words, the prosecutor didn't do anything wrong. You said drop the link right quick. I got you. No problem. Hold up. Drop the link right quick. So that link's for Izzy and Izzy only, right quick. So Izzy, come up here. I'm gonna continue reading right quick. So exactly as the lead prosecutor had described on May 11th that the agreement would operate. In other words, the state didn't do anything outside of the agreement. Let's continue. The state's punishment presentation will be confirmed by the reporter's record. The state thus performed the bargain at punishment the day after denying that the same bargain covered the defendant's testimony. In the end, neither side put on the character evidence the understanding covered. The bargain was performed on both sides through the last day of trial. The only term repudiated was the one most vital to the defense, the defendant's own testimony. Karmelo Anthony was necessarily a witness to what happened under the tent, under the understanding as the state itself had repeatedly described it. He would testify like any other tent witness, and his elimination as a witness was devastating to a defense that turned on his own perception of the threat he faced. By then, the defense had already paid the price of reliance and could not undo the voir dire. Hold on for 1 second. What up, though?
What's good? What's good? What's good? Shout out to you. Shout out to the missus. What's going on, Raw? What's good, y'all?
Hey, Izzy.
Shout out to your chat. Just real quick, so this is what we were trying to tell you earlier, right? So the part that you're missing is this. The reason why Karmelo, the whole plan was for Karmelo to testify, according to the defense.
Yes.
He was always gonna testify, right?
Yes.
When you got to remember, on Saturday is when the prosecution rested and had their last witness, which was Eddie, and then that's when the defense took over, right? They were presenting their argument. In the midst of the defense presenting their argument, and after lunch break, right? The defense was trying to get the judge to give them basically to continue the case till Monday, because they were saying, listen, the rest of our witnesses are not available. They won't be available until Monday because today is Saturday. Can we have time? The judge said no. Okay. They said, well, look, Your Honor, that will make us have to make Karmelo testify early. When they said that, that's when the prosecution was like, well, okay, that's fine, but I hope that you know that our agreement is broached. And they're like, what? You broached the agreement in the very beginning when you did those opening arguments. That's what I was trying to get you to understand earlier. So then when it happened, they started arguing. They got into a big fallout. That's why it was mad long. Remember, while we was trying to yo, what's going on? Right?
It's 3 hours.
Right. That's why that was, because they was going back and forth about this. So what happened was they took a break. The judge said, listen, y'all need to work this out. So they took a break for like 10 to 15 minutes to let cooler heads prevail. They came back, and then they tried to work out the details of Karmelo testifying without them thinking that they're breaching their agreement, so they don't try to bring Karmelo's character into question, because they never brought, or like you said earlier, they never brought Austin or Hunter's character into view because of the fact of the agreement. So the way it looks is that they kept the agreement, but now at the end, they're not trying to keep the agreement because they're saying, well, we didn't think you was gonna let Karmelo come up here. Nah, if Karmelo comes up here, I'm a prosecutor. We're gonna eat him alive, basically. Everything's fair game. And they're like, nah. And they're like, well, you broached the agreement anyway. So I'm telling you, if you bring him up, it's fair game. So that's what happened. So then the defense went to the judge and was like, hey, look, this, we had this agreement. You know about this agreement. And he's like, and he's saying I broke it. And the judge is like, no, you didn't break the agreement. But you have to understand.
Izzy, your mic breaking up. Go back like 2 sentences.
Okay, can you hear me now?
Yeah, go ahead.
Do I sound clear?
Yeah, you clear.
Okay. He said, no, you didn't break the agreement, but you have to understand that if he does what he say he's gonna do, meaning the prosecutor to Karmelo on the stand, there's nothing I could do about it. Because legally, I don't have any basis for any kind of repercussion for what he's doing. So then that's when the defense attorney, when Mike Howard was like, okay, with Judge, okay, I hear you. So can you let us prepare our witness and let us come back on Monday? Because this is out of order. This is out of the order that we wanted to do our witnesses anyway. The judge said, no, you have 10 minutes. He said, Your Honor, 10 minutes is not enough time. He said, you have 10 minutes. So that's when they went to Karmelo to see if told Karmelo what was going on and to see if Karmelo wanted to testify. And then Karmelo was like, I guess, he was like, nah, that don't, you know what I'm saying? Like, no, his parents like, no. So that's what happened.
Got you. So here's the thing, right? Because I needed to remember, or rather I needed to look up who went first in their opening statements. The judge gave both of them 20 minutes. Mm-hmm. The prosecutor went first at 9:30. I'm just giving a quick recap. Pretty much, Worsk said that this has nothing to do with race. This case is not self-defense, and that it comes down to Austin Metcalf pushed and shoved, and Anthony carried out his sneak attack. Worsk said Anthony used a hidden knife, opened his hand, plunged into Metcalf's chest, causing his death, and then ran away. He called it a provoked, unjustified murder. That's pretty much a summarization of the prosecutor's opening statements. Now, in the defense's summarization of their opening statements, because I'm still waiting on that record to come out, there's been a lot of noise around this case. Defense attorney Mike Howard, a lot of completely false information. Howard told the jurors that evidence would show Anthony is a son, a brother, he's a friend, a boyfriend, an athlete, and an A student who graduated with a 3.7 GPA while holding down 2 jobs. This is the first day. That's why I was confused when y'all kept talking about Saturday. I'm like, wait.
No, yeah, opening statement, right? But what I'm saying is the DA didn't pull this out until the last day, which was Saturday, to say, hey, you broke the agreement on the first day. You see what I'm saying?
But they did.
No, but they did. But the judge declared that they didn't.
Right. So, but that's the thing, though. The judge is not going to talk about in public what they talked about in his chambers.
No, they was in private when this happened. This was a private argument with no one around. That's why they was on recess. Remember, they was on lunch. This was a private argument.
No. This is the first day.
No, Sel, you're confusing it. Yes, what you just read is the first day, right? You're right.
Yes.
Right. Those are the opening statements, right?
Yes.
Right. So what I'm saying to you is this. The DA never said anything to the defense about breaking anything, doing anything wrong, nothing like that. So that's why the defense never brought into question. This is what they're saying in this affidavit. That's why they never brought anything into question with Hunter, with Austin, and they never cross-examined those witnesses hard and tried to talk about their character and the fact that there was lying. The reason why they didn't do it, and what he's showing in the affidavit, is all the things that he could have brought to the table. That's why there's quotations. If you look at it, there's quotations around all the stuff. So what he's saying is, these are the things that I was prepared to bring, right? Like you said earlier, but because I had the agreement with the prosecution, I did not bring it, right? I didn't think I violated anything. When I asked you, Judge, you said I didn't violate anything, but yet and still the prosecution is saying, because of me saying that he played chess club, whatever they're saying, that they are going to treat Karmelo as a hostile witness, and they are going to bring Karmelo's character into play. And so what they're saying, the argument that the defense is saying is, hey, look, it's too late for us to go back now. Legally, we can't even go back now. Right? We followed the agreement. We followed the rules. We can't even go back now and put on a real defense for him. And now you got him as a lamb going to the slaughter. And we didn't even play this game. We was trying to play this straight up. Now y'all trying to play dirty. Is that's in essence what they're saying?
This is the thing. Hold on, Izzy. This is the thing. Even if they were going to try to play dirty, right? That's not outside the scope of plausibility or normalcy when it comes to trials, especially trials of this magnitude or of this nature, right? Treating him as a hostile witness, so what? You put him on the stand, and the fact that you need someone to walk you down the road in order to know how to defend your client is unacceptable.
Right, and I agree 1,000, a million, a gazillion %. And that's why he's going to get a retrial, because he had an adequate defense. That's the thing. And see, again, I don't understand why people think that I don't think Karmelo is innocent. I've never said that. Y'all know for the record, I've never said that, right? I've said the same thing over and over again. I can't say that he's innocent. That's ridiculous. Someone lost their life. And I've always had the statement that may God rest Austin Metcalf's soul. So I don't think he's innocent. I just don't think he deserved 35 years, but that's something for another day. My only thing is, let him get a proper defense, let him get a proper trial, and then whatever happens, happens. I'm okay with whatever happens. If you get a proper defense and a proper trial and they find him with 90 years, oh well, that is what it is. That's the justice system. You see what I'm saying?
I do, but here's the thing, right? This is the issue that I have as far as ineffective counsel. The statements that are being made about this clean trial deal or whatever, those are going to have to be substantiated. Now, even if it does boil down to ineffective counsel, right? Here's the caveat. In order for Mike Howard to avoid malpractice, disbarment, and ethical violations, what he would most likely say is that it was a defense strategy. And that if he does posit that, that is likely to be upheld. You can't say ineffective counsel just because someone is a piss poor attorney.
No,
Now,
but he did unethical. He did, like you
Hold
said
on,
earlier.
let her finish
Okay,
right
yeah.
there. Let her finish.
No, my bad.
because what he's doing right now, giving this statement to the appellate team, that could be the unethical violation in and of itself. And I want to be very clear when I say that, because him having a bad strategy is not ineffective. But if he has recordings where he was on the phone with the prosecutor and they had these stipulations, that's a different story. Conversations held in chambers, if the Judge Roach, and the prosecutor says that's not what those conversations were like, and that's not the quality of what we discussed, then he looks like a crazy. That's where the ethical violation is. Does that make sense?
Yes, but also, right? Like you pointed out before, he did not provide an adequate defense for Karmelo. He didn't provide a defense at all, right? And the very agreement to those terms.
Izzy, what happened?
The music is playing.
Right, that's what we both like. What the hell?
Oops, my bad. Hold up, time out.
Some music just started playing.
My bad. I was trying to go to a website where we can read the opening statements, but it's music playing on the website. My bad, y'all. My bad. Go ahead.
Okay, so I was like, damn, did I get hit with the Sandman? The Sandman came out like, dun, dun. Hey, yo, no, but see, this is the thing, right? The mere fact that he didn't get a defense at all, and he hinged his whole strategy on accepting a bogus agreement with the DA, in and of itself is incompetent defense. It's not like a bad strategy. That's incompetent defense. So they absolutely have a case, and especially since the DA reneged on the agreement. That's the problem.
So
right. I can get with you right there, right? And I agree on that part. The point is, he's going to have to prove that he made that type of deal, right? He also could just be feeding this appellate team a little bit of anything, a nothing burger, right? Would you agree that that's something he could be doing?
That's possible. That would be super crazy,
That'd
right? That would further let them know that this nigga was in on the fix, right?
Right, but then that would mean he would get disbarred, right? Because if he's feeding them whatever it is that they want to hear to make it sound good for an appeal, but it's not verifiable, and that's not what happened, then he's going to get an ethics violation for what he's saying in the appeal, and that doesn't necessarily constitute ineffective counsel either. It would just be that he was just a lazy ass attorney, and he felt like he would be able to get away with just sitting in the courtroom and getting a check. That's where I am with it.
I mean, we'll see. It's very interesting, to say the least.
Yes.
Let me read this right quick, because I think this is important. What the fuck? Ah, come on, Streamlabs. Anyway, let me read this.
You can't be like me. You can't be sexy like me.
First of all, just wait till my Streamlabs start back up, and you're going to find out what it is. All right, so really quick. So, all right, so defense attorney, because like I said, I needed to know who went first. So the prosecution did indeed go first.
They went first and last.
Yeah, that's based on an agreement between the two of them. So opening statement set to begin at 9 a.m. So then I have to scroll back up here at 9 a.m. Prosecutors have made several pretrial motions for the judge to consider. The defense has not objected. That's a problem. Everyone in the courtroom rose as the jury entered the courtroom and took their seats. Each side is allotted 20 minutes for opening statements. First Assistant District Attorney Bill Wersk began for the prosecution. He plunged a knife into his heart and ran away. Wersk tells jurors describing what he says Anthony did to Austin Metcalf. Wersk calling the killing an unjustified provoked murder. This case is not self-defense, he said. This was simply senseless. Wersk told jurors that they would see surveillance video and that video tells the story. He references words witnesses claim Anthony said before Metcalf was stabbed. touch me, see what happens. Worst argues that Anthony provoked and goaded Metcalf into touching him. This is an unprovoked, unjustified murder.
Can I ask you a question?
Sure.
Wouldn't some of that, if we play the semantical game, right? Of the defense's opening statement, wouldn't most of that in the beginning be a character assassination?
No,
no, it wouldn't.
I'm gonna tell you why.
Wait. Him playing chess is not a character. Him playing chess is a character, a statement. But you saying that that he basically did it in cold blood and that basically he provoked it. That's not a character. That's not a character assessment.
So that's not a character assessment. That's him open. Now, this is why I wanted to read the opening statements. This is why I'm glad that you're here, right? So him saying this case is not self-defense. He was simply senseless. That's not a character statement.
No, I'm not saying that's not the one I was talking about.
Okay, well, that's why I'm going back and I'm reading through him, right? He plunged a knife into his heart and ran away. It's not a character statement.
That is, but we could go past that. That wasn't the one that I was talking about.
I got you.
That's facts. That's the facts of what happened.
He stabbed him and then he ran.
Right. It's also a fact that he plays chess. So
hold on. Wait. No, we're gonna do this piece by piece.
We're gonna do this clean, Izzy. We're gonna do this clean.
Nah, I don't trust y'all.
That's cool. He plunged the knife into his heart and ran away. We seen a video where he plunged the knife into his heart and ran away. Worst called the killing an unjustified provoked murder. It's not about character. That's about
provoked. No, provoked is absolutely about character. Provoked is an absolute character assassination word. Provoked.
Gotcha.
Right?
But per the witness testimony, what did the witness say? That this
but that's not a fact though. See, provoked is not a fact. Provoked is a matter of opinion, right? Because there's a large group of people that say that Austin Metcalf provoked it, God rest his soul, right? But then there's also a large group of people that said that Karmelo provoked it by not leaving. So that is extremely subjective, and that is in fact a character assassination. If you could say that him saying he played that the defense saying he plays chess,
we haven't got there yet.
We
haven't got there. We haven't got there yet. We only in the opening statements of the prosecution. And everything that he's saying, he's going to present as evidence before the jury. Can he present, per his case, that this was unjustified and that Karmelo Anthony provoked this murder? Well, when we read through the questions he was asking of the witness, the video, the evidence, he feels that this is provoked by Karmelo Anthony. That's not character. That's based on his case that he's presenting. He's not talking about Karmelo Anthony being in a senseless or a defenseless position and then saying that, hey, yeah, he's a provoking type of person. No, this was an unprovoked murder. The word provoked used in itself can be, but a unjustified provoked murder, that's not character. That's speaking to the case. But let's continue. This case is not self-defense. This was simply senseless. That's not character. Worst told jurors that they would see a surveillance video and that the video tells the story. He references words witnesses claim Anthony said before Metcalf was stabbed. Touch me, see what happens. It's not about character. That's a statement of fact. Worst argues that Anthony provoked and goaded Metcalf into touching him.
Again, goaded, provoked, and again, I get it, right? I get it, but we can't be disingenuous and dishonest and make it seem as if those are not character assassination words. Like maybe it is legalese, maybe it is a part of a law, whatever the case may be, or a definition. At the same time, he has specific placement of those words for impact and for effect. Right now, this is another thing, real fast, right? The mere fact that he kept asking these lay people, children. We all agree they were children.
We haven't got there yet. We haven't got there yet. And this other, and I appreciate you saying that, but everything that he said so far is dealing with what happened under the tent. Would you agree or disagree?
I can agree to that.
Okay. This is an unprovoked, unjustified murder. This killing is senseless. At one point, Worst points to Anthony, who at the time was a student at Frisco Centennial High School, attending a trap meet at Metcalf's Frisco Memorial High School. This man, Worst told jurors, made a beeline for the memorial tent. Several Memorial athletes told Anthony to leave, Worst said. The tent, he said, was their locker room. Worst said, and who's that just came up?
Uda the shooter.
All right, I said the link was for. All right, I'll let Uda up. Uda, what's up?
What's going on?
All right, I ain't letting nobody else up. All right, I ain't letting nobody else up. All right, hold on, real quick.
Salute, Uda. What's up?
Salute, bro.
Where you just made me look. Okay, that's where I was at. Goaded and taunted and provoked Metcalf. Worst said Anthony produced a knife and swiftly and plunged it into Austin. Worst said Anthony then ran off and tried to blend in, which we seen that on the video. Worst told jurors that students at the track meet pointed out Anthony as he is trying to leave the track meet. It's not character statement. Worst told jurors that when an officer arrived on scene, he encountered Anthony. He radioed, "I have the alleged suspect." It's not character statement. Anthony then told him, "I'm not alleged. I did it. We have the body cam footage." It's not a character statement. Anthony also allegedly told the officer, "He touched me first, and I told him not to." Hold on, y'all. Hey, y'all got to be quiet. Y'all hear my microphone on? According to Worst, he told jurors...
Baby, wait, excuse me, y'all. Excuse me. Sidebar. Real life conversation. How can the kids hear that your microphone is on?
Oh, hey, look here. Shut up.
All right.
Hear me talking. Y'all ain't shit. According to Worst, he told jurors toss the knife and tried to slip away from the scene. He told jurors they will see a video from the scene and that they will hear from the witnesses. You cannot provoke someone and produce a knife and take a life. That's it. So, and I can see how you can play semantics on that, but when it comes to legalese, he didn't say anything about Karmelo Anthony's character. Now, let's go over to Mike Howard's opening statements. There's been a lot of noise around this case. It's not a character statement. A lot of completely false information, not a character statement. Referring to Anthony by his nickname, Mello, I wouldn't even conclude that as a character statement. He described his client as a son. He is a brother, the oldest of four. He is a friend, a boyfriend, a student who graduated with 3.7 GPA while holding 2 jobs, playing football and track. Now, I'm going to ask this very simple question. On day 3, after jury selection has begun or has ended, and the prosecution has given its opening statements, speaking only about what happened that day, Mike Howard goes in his opening statements and talks about how his client is a brother, has nothing to do with him, what happened under the tent. The oldest of 4 has nothing to do with what happened under the tent. A friend, a boyfriend, and a student with a 3.7 GPA while holding 2 jobs, playing football and track. Please tell me, if that's not a character statement, what is it? Y'all got it? This is day 3. This isn't Saturday. That's why I was confused when y'all was saying this. When did this happen? Because I'm reading from the opening statements that the defense attorney made, and there was supposed to be an agreement. And per the attorney's proposal of this agreement, we're only going to talk about what happened that day. On day 3, Mike Howard blows the agreement out the water and opens with a character statement. So I'm going to ask the question like I asked before. If you open the door, do I have to make mention that you opened the door? Uda or Izzy? Damn, am I muted? Can anybody hear me?
What's the question?
They on mute.
Oh, the question is on day 3, which is 2 days after, which is after jury selection. This is the very beginning of the trial. This was not Saturday. That's why I was confused when y'all kept saying it was Saturday. This wasn't.
I never
Saturday.
said anything was Saturday.
Okay, so maybe I was
to the beginning of trial. So at the voir dire, the jury selection process, right? So after they came up with this agreement that I'm talking to you about pre-trial, they came up with this agreement before all of that. All right, that's what I was speaking to. How the agreement was had way before the trial even started. When we get into after the case started, then the judge pulled away overflow rooms and all this other stuff happened. That's another thing. But I'm just saying the agreement that they made was based upon from the very beginning, from pre-trial. So when he came, the prosecution, Bill Werski, when he came to come and say that, yo, you violating the agreement, he actually been knew, if he thought that he did, he been knew that he violated the agreement in his own mind, but yet he let it ride, did his whole case, and then brought up that he violated the agreement only after he finished his own case. Which
Absolutely.
Right, when it was too late, where it was too late for them to actually do their job. Right.
Yeah, that's what I'm saying. So if you feel like a person violating, then bring it up, then flag it. You know what I'm saying? But he didn't even flag it.
Right, but this is the part, okay? Even if he did do that, right? Let's just say he did whatever he did. You know when you make an agreement with somebody, right? You know when you make an agreement with the company, when you sign a contract or whatever. You know when you're in violation of said agreement. No one has to tell you, oh yeah, by the way, you violated the agreement. Now I got to pop you. That's not how that works. You knew what it was when you decided you were going to violate said agreement, and you should have been preparing from there.
Not even the judge agreed. And see, this is the thing. Even the judge agreed with the defense attorney that he did not violate their agreement. That's not that him saying that he didn't say he was on the chess club. He said he played chess as a hobby. And so that's basically making I know, but that's basically making him look human. It's not a violation of the agreement. He has to at least try to make his client look human, especially in the open statements, right?
But go back to the agreement really quick. In the agreement, I'm not going to bring up his humanity or his character. Y'all not going to bring up the Metcalfs. Mike Howard agreed to this.
No, he didn't say his humanity. He said his character.
I'm summarizing.
Right. So that's a different thing. So saying that he's a brother of four, the
has nothing to do with the tent.
No, but again, it does.
Okay.
Though.
Hold on. Let me explain to you the difference in an opening statement that would have been more acceptable in this scenario, right? On April 2nd of 2025, it was a rainy day. My client, Karmelo Anthony, came to whatever Cuckendall Stadium in order to participate in a track meet. The weather was atrocious. He was just looking for shelter from the storm. He approached the tent and was invited to come underneath and sit down. As he was sitting there, he was accosted by a group of children telling him that he needed to leave and violently approaching him, grabbing him and tearing at him. And he had no choice in that moment but to reach into his bag, grab his weapon, and stab Austin Metcalf. It was a tragedy, sure. But this was simply an act of self-defense. Because what we will show here today is he had no other choice but to do so. See how that's different without bringing up anything outside of that, and it's still a good opening statement.
Yeah, I get it, except for the fact where you said stab. But yeah, I get it because you don't want that in there, even though that's all true facts what you said, and even though that's very creative and good, actually framing, right? But you don't want to say stab because that's going to put it in the mind of the jury, and that's going to have an unfavorable outcome. But this is the thing, right? We have to admit, right, that again. If the judge says, if they go before the judge and they say, Judge, he's saying that I broached the agreement. Is this a breach of the agreement, Judge, from your understanding? And the judge said, no, from my understanding, it's not a breach of the agreement. Then that should be what it is.
I have a question. Does he talk about in this 193-page thing what that argument was exactly about? Does he make statements on what was said?
Yeah, well, so to speak, right, Uda? Because basically the argument was the fact that the argument came when the judge was like, yeah, it's not a violation, but when the DA kept bringing it like, yo, you violate, and then the judge was like, well, listen, it's not a violation, but truth be told, there's nothing legally I can do. if he decides not to keep up with the agreement. That's where it kind of went off the rails.
Right. So if he's not, I'm sorry, Uda, I'm gonna say this and then you got it. If Mike Howard is not going to keep to the agreement, then I'm not going to keep to the agreement. Y'all see, this is why I was making that argument on your show.
Right, but according to the judge, he did keep up with it. See, the judge is the arbiter of that. And so according to the judge, he did keep up with the agreement. It wasn't a violation of the agreement, but
I'm talking about the prosecution.
Right. No, meaning that the defense kept up with the agreement, but the judge cannot enforce it if the prosecution decides to renege on the agreement. That's the basic point. That was the basic premise, and that's what put the Karmelo Anthony actually testify in jeopardy. That was the thing.
I checked it. Oh no, it was supposed to be Uda. Uda can go and then
Uda, go ahead, Uda.
If you can check again, bro. I'll go after you. Go ahead, bro.
Thank you. I just try to keep, things in order. But here's the thing. Once Mike Howard knew he violated the agreement, right? And he already opened the door, even a little bit. At that point, he was supposed to say to himself, all right, we in here to fight dirty now because we done already pulled it, right? Because that was a little slick stuff. So he should have been very aggressive at that point, knowing what he was going to be up against when he started to present his case. He should have been very much objecting. He should have been very much cross-examining those young people very firmly and aggressively to call out their lies and not giving the prosecution the opening to make him look a complete and total fool. And he should have prepared his witness, Karmelo Anthony. Listen, I'm about to turn it up. So let me prepare you, your mother, your daddy, your auntie, your cousin, and whoever else we got on this list for a brutal cross-examination, because I'm going to gaslight them to think that they're coming into this easy and they're going to go back hard on us once we get on the stand. Because if you bring a neurological expert to the stand, sorry, no matter how hard you try to come at them on cross-examination, you can't argue medicine. If you bring a mother on the stand, no matter how hard you go against her and cross, all she's going to do is cry. You understand what I'm saying? And with Karmelo, what was actually effective for Kyle Rittenhouse was on cross. He was brutalized. And he held his frame. He cried a little bit. And them tears is what brought him his freedom.
Yeah.
Right. You're right. But I'm sorry. You're right.
I would have set it up just like that. I would have let the process, even if I would have let the prosecution have an easy case, I would have flipped the script and put Karmelo on. Because then if you go hard in the paint in front of the jury and I didn't go hard in the paint on your witnesses, now you look crazy. That weakens the prosecution's case.
Well, it could.
Hold on.
Deal initially. Because that whole deal from the beginning limited all of those things. Even when the mother was called, right? Because the mother was called before the sentencing, right? That's the only time. But even she was limited to even the questions that they would ask her. She could only testify that that's my son and please have mercy. That's it. Nothing further. All these parameters were set. All right. So even for him to even speak about why he had the knife, for him to speak about he was scared, would have also breached the agreement and opened the door as well. So this whole agreement from the very beginning limited all of those factors. The defense planned on cross-examining witnesses and even making them hostile witnesses if they had to. The defense also planned on calling Karmelo Anthony only after they called their other witnesses, and they was going to call him last after they built their whole case, right? So all of these things fell apart because of the same said deal. So they're still trying to keep it real to this said deal when Mike Worski, who created the deal, is not even keeping it real to the same deal that he created. So it's not like the defense created this deal. The prosecution created the deal. I don't think that they should have ever entered into an agreement with the prosecutors. I ain't never known a prosecutor to ever love no defense. That's just period. That's what I've seen in my whole life in the court cases and shit I've seen in my life. But hey, that's it. But I think just the agreement from the very beginning limited all of those factors. He came back to say, yo, I didn't even think your client was going to testify. When everybody know, even a layman lawyer knows that in a self-defense case, the person that's in the self-defense case, the defendant must testify. So as a prosecutor, you were a lawyer way before you even became a prosecutor, but now you acting like you don't know what the hell's going on in the case. Like, come on, stop, bro.
Yo, can I say this real fast?
Yeah,
Go
it's
ahead,
good.
Izzy.
Real fast. So first best Gigi is saying that if the judge said the defense hadn't violated agreement, then the prosecutor could not violate it himself. That's not true. And that's what the judge was saying. The judge said, hey, look, he did not violate that to the prosecutor. It was not a violation. But he said he turned and said to the defense, hey, look, you did not violate it. You're right. However, if he decides to go down this path that he's threatening to go down, there's nothing really that I can do to hold him accountable legally for this. So he was letting him know that, yo, you're right. You're right in what you're standing. You're right in what you're saying, defense, but there's nothing I can do legally to stop him. So you have to know that, and you have to let your client know that from the beginning, and you only have 10 minutes to do so.
This is true, right? But here's the thing. Here's the thing about it. This is on the parents ultimately, because I want you to picture it, Sicily, 1933. You paying somebody, and somebody says to you that you're paying your employee. I'm not going to give you 100% because I done made a sideways deal with the prosecutor. Let's be very honest. This case played out how the prosecution wanted it to play out. Right? Which means, what am I paying you for? We could have had a public defender. That could have been $75,000 still in my pocket. So it's on the mother and the father for accepting that defense in the first place. That's number one. But number two, the judge can't make him not go hard on Karmelo on cross, but Mike has the ability to object. Let's say the quiet part out loud. Mike was just being lazy. He didn't want to do the job, and the parents were being foolish as hell.
Yeah, I think he was just being plain incompetent, to be honest. But yeah, I mean, I get it. He was being plain incompetent. But I would say this. This is what I would say. I would say it's beyond an uphill battle when you, like you said, you have 21 witnesses, a lot of which had different statements. There was a lot of information that wasn't brought to the table because of this agreement. And then at the end of you letting all this stuff slide, you letting all this character, you letting it go by as if Austin and Hunter were these good kids and nothing was wrong with how they behaved and how they act. And then you let the prosecution ream Karmelo. Yeah, I don't think that would have went over that well. And I think he probably would got more time, to be honest.
Do y'all mind if I read what happened on June 8th right quick? Because that's the crux of where we at, right? So the final day of evidence after the defense has spent voir dire, is opening the entire cross-examination of the state's case, and the first day of its own case, honoring the bargain, the lead prosecutor announced that the agreement had never contemplated a testifying defendant, and asserted that defense counsel had already opened the door by mentioning and opening that the defendant played chess, a position the court itself rejected. So the court, like y'all said, because this is my first time reading this, the court agrees that the defense did not break the agreement. The court then advised the parties that it knew of no mechanism at its disposal to enforce their understanding. An understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record. That's bad. You're now resting your case on the prosecution's bad case.
Facts.
That's not good. That's terrible.
At all. Exactly. Horrible.
But here's my problem. And I'm glad that we come to understand it, but here's the problem. You opened the door. Let me finish. Even if the judge disagrees, I can disagree with the judge and then say, you know what? You're right. He didn't break the bargain. But he's going to put his witness on the stand, right? Okay, cool. So I'm not going to break the bargain either. Wait. I'm only going to talk about that. Go ahead, baby.
But he's not. That's the problem.
Wait. Because the defense attorney also has the right to redirect.
Absolutely.
So saying that this agreement went south or whatever is inconsequential because he could have called the one of the witness back to rebut and to redirect.
Even after they closed their
Yes.
after they closed their argument down. Are you sure about that? Because I thought the prosecution would be able to do that, but I don't think the defense, being that the burden of proof is on the prosecution and not on the defense, I don't think in this particular style case the defense could have redirected after the prosecution already they would have had to do it before the prosecution closed their argument. That's the point.
They could have called the rebuttal witness. They could have called the rebuttal witness.
It still was limited by the constraints of the deal, because the deal was not to go to character evidence, extraneous evidence, all of these different things. So I think that was still limited. That's how come the defense got off their case as clean as, I mean, the prosecution got off their case as clean as they got it off, based on the same deal. So that's where the whole, I mean, it's the prosecution. Who's going to trust them? So if you trusted them, that's your own fault. It's some foolishness for you to even trust them. But, you know what I mean? I think the prosecution did what was good in their best interest. You know what I mean? Why would they want to be looking out for the defense? So,
right,
you know what I mean?
The deal is totally relevant. The deal is not irrelevant, y'all. The deal is totally relevant to the fact of why he got inadequate defense. It's totally relevant.
But the deal is relevant.
But hold on, wait.
Because that's why Karmelo didn't testify ultimately, because even the judge said, look, man, if you go in, you may be even now at the end, now when they're talking about they're going to call Karmelo, which they've been saying through all these meetings that they were going to call him as a witness and as the last witness. Now, later now, while Bill Werskey's bringing up the argument that he even broke it for the chest thing, now they get into a conversation where he's saying, like, now the judge is telling him, Judge Roach is saying now, no, I mean, if you call your client now, for your client to even say that I had the knife because of this and I was scared, then you would also be opening the door. So even when he was talking about bringing up the coach, and he said, what would the coach testify to? That's not about character evidence. And then he said the coach is just going to come and testify that he witnessed the seizures because he's seen them and stuff like that. So it's not about the character, it's just that he witnessed the seizures and that. So ultimately, when they went into the back and forth, even about that, ultimately, they didn't even call the coach to even talk about the seizures. You see what I'm saying?
Gotcha.
So this deal was based on all of those things. It factored into all of those facts, bro. Trust me.
But really quick, I just wanted to read this right quick because Gigi raises a point. Gigi says, enforce, there was no paperwork on the agreement. If there's no written record, there's no way to bind the parties to it.
Right. That was the point at the end. That's the truth.
Right.
But
so
the
if there's
created a motion in limine just to substantiate it, this is what they made the defense do.
But when did they go ahead?
Where is it? Where is the motion of limine?
Allegedly, it was in the beginning.
This is what they did. This is what Mike Howard said in the affidavit. He said, so because remember, the judge ain't tell him at that time that he couldn't bind it and all those things, which he probably knew that he couldn't bind it, but he never went into those things then. The only binding time was later on when the whole discrepancy happened. But after they came up with the agreement and they went in front of the judge, I'll bring it up to show you. I'll screenshot it to you. So after the judge, I'll bring it to you. So after the judge and him came together, you know what I'm saying? And then they said, we drafted a motion in limine and all of these things to, I guess, to have something substantiated, because it was just all verbal. They were talking on the phones about this deal while they were solidifying multiple times on the phone. So I'm gonna bring up that wild cell read or whatever. I'll try to find that for you. I'll show you.
So really quick, oh, that's what I was reading. All right, so an understanding that throughout the months the defense relied upon it existed on no record because it had been reached and presented to the court off the record, and that if the defendant testified, the door to character and extraneous offense evidence would almost certainly be open. Allotted 10 minutes, the defendant elected not to testify. By then, somebody has a banging going on. By then, it was too late to conduct a different voir dire, deliver a different opening, or recross the state's witness. And at punishment, the defense case was reduced to the 3 pre-approved questions of the defendant's mother. The state, for its part, called no punishment witness and offered none of the extraneous offense or character evidence cataloged in this 75-page notice. Did I read this already? Hold on.
Nah, but that was for the you read the other part. But see, this is the thing. Can you hear me?
Oh wait, yeah, I did. Wait, hold on. That's my fault. I did read that already. My bad, y'all. Hold on. I got to get to the part where I didn't read. The case of June 8th and find out the evidence. Open the door, never contemplated, and the party vibe, understand. Oh, so they just repeated it. Ah, there it is. All right, so this is the new part. All right, so I'm gonna go back a sentence. Right here. On June 8th, on that final day of evidence, the state asserted for the first time that the defense had opened the door in the opening statement and that the understanding had never contemplated a testifying defendant. And the court advised the parties that it had no mechanism to enforce the understanding. It would rule under the rules of evidence alone. Faced with that reputation, the defense abandoned its plan to call the defendant and to present certain expert testimony. The state's own conduct then corroborated the understanding it had just denied. At punishment, it called no witnesses and offered none of the extraneous offense or character evidence cataloged in the 75-page notice. Resting its punishment case immediately, precisely as Mr. Worski had described on May 11th, the agreement would operate. A matter the reporter's record will confirm. The state's punishment presentation and circumstantial evidence from which the court may infer the parties' shared understanding. At minimum, it is a fact that should be explored at the evidentiary hearing. And the final ledger confirms that asymmetry of the breach, neither side ever introduced the character evidence that understanding covered. The state's forbearance costed nothing because the defendant, silenced, never opened any door. But the defendant didn't have to be silenced to open the door because you, as the representation of the defendant, which is Mike Howard, you opened that door.
But he didn't. If the judge said that he didn't, then he didn't open the door, bro. That's the whole thing. Y'all don't know why y'all don't understand
that. Claim from Mike Worski trying to be
right
slick.
trying to be slick to put some salt in the game.
He got caught with his hand in the cookie jar because the judge himself, the man in this trial, said no, that's not true. He didn't break he didn't breach nothing. So that was just a claim that the prosecutor was trying to be slick with. The judge
I agree
said it,
with
and
you
I bring
on
it up and show you that the judge said that. He said, no, it's not, bro. So it doesn't matter what he said with that because it wasn't true.
Right, and I agree with you on that. But then if we're still sticking to the agreement, you're going to put Karmelo Anthony on the stand. Because wait, hold on. Per the agreement, if you don't bring up the Metcalfs and I don't bring up his character, Carmelo's going to testify.
Okay.
Wait, hold on real quick, bro. If I can say this, that's not true, Sel. This is the problem. The problem was as soon as he made it known, okay, now I got to bring Karmelo up out of order. So I got to bring Karmelo up on Saturday instead of Monday like we planned after everything was said and done. And that's when the prosecution like, what? Nah, he's not. Nah, if he comes up, we're gonna treat him like a hostile witness. And I'm like, wait a minute, our agreement was such.
I didn't think about. He said this agreement didn't plan for your defendant to come and speak.
I got you, but I'm saying the same thing in a different way. The point that I'm making is that. So basically, this was a threat. This was like, yo, if you put him up on the stand, we're gonna eat him up. So that in turn messed up his whole defense basically because his plan was to bring Karmelo up knowing that they wasn't going to talk about his character, knowing they was only going to talk about the events of April the 2nd. But when he flipped on the agreement and he said, yo, if you bring him up, because we didn't think you was going to bring him up at all, like Uda is saying, then that's what deterred them from bringing him up. And since they didn't bring him up, that's what he's saying. He basically kept with the agreement. So the thing of it was he just did that to put salt in the game, to keep Karmelo from being able to testify, or to put the fear in if Karmelo did testify, he was going to breach the agreement. That was the point.
Hold on for a second. Hold on, Uda, because Raw was trying to talk. Go ahead, baby.
Yeah, what's this?
Just skip down to page 135. We could just read his affidavit.
Page 135.
I got the thing for you in the back too. When y'all ready
is that page 135?
Yeah, Uda, you got 135?
No, I remember I got the page to show you the lemony thing, but I got all of that. I got the whole document.
Okay.
I got the lemony things screen shared in the back when y'all ready for it. When y'all ready. But I was just
page
saying,
135.
yeah.
All right.
I was just saying though, it went so much an agreement that the defense had to go line by line of what he would go through with Karmelo Anthony. And when do you see a defense go to the prosecutor and they go in line by line what he's going to be doing, his defensive strategy? And Bill Werski was standing over his shoulder looking line by line of what he was going to go through.
It's called discovery.
Yeah, that's discovery.
No, that's not discovery.
That ain't discovery. We talking about
discovery,
this,
y'all.
That's
No.
discovery. This is off the record.
That's not discovery.
Wait, hold on, wait. Motion and limine comes in after discovery.
I'm not even talking about limine. I'm talking about with the case when it comes to
right. He's talking about his actual strategy of
defendant.
exactly what he was gonna ask Karmelo, how Karmelo was gonna respond. He had to go through that with the prosecutor in order for the prosecutor not to trip. And by the time he got to Karmelo was like, nah, I don't feel comfortable. And so that's why they in the 10 minutes that he had to revamp.
But here's first of all, go ahead, Raw, because y'all did cut Raw off while she was speaking. Go ahead, baby.
So anyway, what I was saying is it's discovery. In discovery, you got to give all your facts of the case to the other attorney. You have to. You don't have to tell them how you're going to use that, but you have to give them everything. You have to give them depositions, and everything. You have to give them your exhibits, your pictures, and everything. That is discovery.
That's the
But before we read his affidavits, let's look at the motion of limine, because even in his affidavits he said there's no motion of limine on the record. So let me see.
So look, it said we agreed that the best way to document such of an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. So I drafted the motion in limine as described above and sent it to Mr. Werski by email, and it was hand delivered to the judge on the opening day of trial. So I'm saying,
but
so
wait, wait. Let me read that. We agreed the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, extraneous evidence applicable to all witnesses. So in other words, he covered up a backdoor agreement by filing a motion in limine. That's what this is saying.
Exactly.
Right?
Yes.
Right. But that's the problem. Wait. Hold on. That's the problem.
It wasn't a problem.
Wait, hold on.
Wait. The paper.
Listen, I'm reading.
Come on, then. Read the whole thing. Then.
Hold on. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During the meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous. I got to make sure I read that correctly. Extraneous evidence as it applies to both sides during both guilt/innocence and sentencing phases, as long as no doors are open or false impressions given. That's in quotations. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous. Is that extraneous? That's extraneous.
Extraneous.
That's applicable to. I'm doing that for. If y'all haven't noticed, I'm doing that for a reason, because I'm getting ready.
Because you're an asshole. Mm-hmm.
Yes.
Go ahead.
Well, no, because I'm getting ready for something. You know what I'm getting ready for. That's what I'm going to school. So we agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony. But if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. So I'm gonna make sure I got this understanding, and y'all can tell me if I'm misunderstanding this. As long as we don't mention it in public, it's a fair trial. Yes?
No. But that's the thing. That's why it's shady, it's unethical, and it's bullshit, right? Because at the end of the day, it's so really what it's saying is as long as we don't mention it in public, it will not be under scrutiny, and it cannot it cannot tamper with the integrity of the trial, so to speak. Even though this is an integral thing, because they have to do it in the back door, they have to do it in the shadows, and he has to do, that's the good faith. That's basically the good faith omen to show, hey, look, I'm showing good faith by doing this because I shouldn't be doing this. So that means that I'm gonna keep my end of agreement. So I'm expecting y'all to keep y'all end of agreement as well.
Okay, cool. Now, I appreciate that. Now scroll down a little bit. Defense's understanding of the agreement. I want to read that. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description by Mr. Worse described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language, Mr. Worse repeatedly used the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would on any other eyewitness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worth's words in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses, such as the memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. So the defense was under the impression that they viewed Karmelo Anthony as a witness. Am I reading that wrong?
No, you're reading right.
Okay, this understanding of the agreement was further confirmed by
the defense.
No. The prosecution.
No. See, that's
go back up. Wait.
Hold on, Sel.
Go back up.
Hold on, Sel. Give me a second, because I caught something.
Because they saying that.
Hold on. Uda, give me a second. You said the defense, and I said you're not reading it wrong, because it is the defense understanding. So this is the problem. When it came, this is upon hindsight. You got to remember that this is after everything was said and done. So when it came to when they was gonna put Karmelo on the stand, the prosecution made it seem like they never had that understanding, which is the whole problem to begin with. So that's the thing.
But here's the problem, and Gigi nailed it right on the head, because that was exactly what I was about to say. It's not preserved. Everything that you want seen in an appeal, you have to preserve it in evidence. This motion of limine does not talk about the agreement. It talks about characters, it talks about witness, and it talks about what's the other thing that it does? Talks about expert witness. That's what
extraneous.
Right. Yeah. So this agreement that they had will not hold. I'm sorry, it won't, because it's not preserved. You covered up an agreement by using a motion that had nothing to do with the agreement. There's nowhere. Wait, hold on. Wait, listen. I'm reading the plain language that I'm seeing in front of me.
Yeah. And that's why he got railroaded, and that's why
by his own attorney.
Yes.
Wait. But here's the problem.
But the train tracks was created by the prosecution.
Hold on.
Train tracks and the lack of stop sign.
Hold on. Here's the problem, and I need y'all to look at this as if you were an appellate judge. You're looking at this with no bias, and you see, a motion in limine. Well, let's look up what a motion in limine is. Bang, we look it up. All right, cool. He filed a motion in limine. We can't talk about character. We can't do this. We can't do it. Okay, cool, no problem. So let's read through the case. We read through the case. Well, the judge said that nothing was broken, and okay, cool, no problem. Now we get to this affidavit or this statement where he says, well, actually, this is what actually happened. And you agree to this months in advance?
Yes.
Yeah.
But look,
Karmelo Anthony. Well, hold on. We're quick and down. I'm gonna pass it to Raw. Yeah, Karmelo was railroaded. You know who put him on the track? Mike Howard. But you know who hired him? Anthony's family.
But
He don't get it. Wait, he don't get it. Wait, because I'm passing through. He don't get a retrial because the prosecution fucked up. He don't get a retrial because the judge fucked up. He don't get a retrial because Mike Howard fucked up, because an appeals court is if the court fucked up. Go ahead, Raw. You got it, because I'm gonna step away for 1 second.
And then let me go after you, Raw, please.
Now he gonna step away while I'm talking.
I'm just getting some water. I'm just getting some water.
Jesus Christ. The point that I was saying is we really need to get into this man's affidavit, because Mike's affidavit talks about a gentleman's agreement, right?
This is it.
No. That's not it. That's a narrative. That's a narrative.
This is all part of the affidavit, though. This is a.
Wait, hold on. Let her finish. Let her finish so we can see where she's going.
I'm making sure that Raw knows that this is the document. I'm just making sure Raw knows that.
But she's not going there. Let's hear where she's going.
So what you're looking at is you're looking at the narrative that the appellate counsel is putting together based on the depositions that they took, that they included as articles in this case, right? But when we actually look at his affidavit, in his affidavit at point 5, at point 5, he says Mr. Werskursky referred to it as a gentleman's agreement. We're dealing with matters of law. Who's talking about a gentleman's agreement when we are talking about the law? So we could go ahead and kick it back and forth, kick the bobo until Sale come back, because I want us to go
I'm back.
Okay, you're back. Good. Go ahead, say what you guys say.
Can I say this? Oh, wait. I asked for next real quick.
First Izzy, then Uda, then we're gonna pull it back.
Put ice in that water, Sal?
Hell yeah.
Hey, let me hold on real quick. Let me just say this. This is the thing, though. Legally, this is a fix. Legally, this is damning and damaging. They literally, think about that. The defense filing for limine is really an admission of no defense at all. Because if they're not talking about the character of Karmelo Anthony, good or bad, good in the defense, right? If they're not talking about the character of Austin and Hunter, meaning bad or things that would substantiate their argument, Karmelo didn't get a defense at all. He didn't get a defense. Like he said, he didn't get a defense. And so he was entitled to a defense, and that attorney was supposed to do everything that he can fervently to defend Karmelo. But he made a gentleman's agreement, quote unquote, to not defend Karmelo at all. That is negligence. That is criminal. That is unethical. And absolutely, even with him saying it himself, that absolutely is going to give Karmelo another trial, bro. I promise. Watch what I tell you. That in itself, all of that in itself, because again, the judge signed off on, agreed to it. The DA agreed to it. And even if we say we don't believe him, what was that 3-hour break about? What was all the us waiting to see what's going on? What was the fact that the judge was rushing the process and literally said that he wants to wrap this up on Saturday?
Right. So this is the thing, right? The judge wants to wrap it up because this was a high profile case and there was too much stuff going on in his town and in his city, right? That part we all can agree on. However, pick the part is right. You can't get an appeal based off of bad strategy. However, what this attorney is doing right here, like how I said, he's making unsubstantiated claims. Now we're going to read through it. We're going to talk about it. Okay. So he says, I'm Mike Howard. I'm at least 18 years of age, of sound mind. I am competent and qualified to make this affidavit, blah, blah, blah. I was trial counsel supported by second co-chair counsel, Toby Shook, third chair, Tasha Gupta, and a briefing appellate co-counsel, Mike Mola. Why would you have an appellate co-counsel when you're not one of the appeal attorneys, right? This doesn't make any sense. Who represented Karmelo Anthony in this case?
That makes sense sometimes. That makes sense. Okay. Because, you need to, just in case how it goes, because let's say in Diddy's trial, right, you had Mark Agnifilo, right, who was the lead attorney on the case, but yet Mark Agnifalo's wife is like one of the big people in the appellate court. She's an appellate attorney. So just in case it goes wrong, we still got people that's around that got, you know what I mean, that got knowledge of these type of things, so that the way you file your motions, the way you're supposed to do things during the trial on the record, you need people that's good with the appellate things, because just in case it goes left, just in case when you set up everything for the appeal, you know what I'm saying? But I don't think that they set up a lot of things for the appeal at all. That's what I'm saying.
Right. That's what I'm saying. So to say you had an appellate attorney and you didn't really make the utterances to substantiate, and really shore up the appeal just in case, is also speaking to bad strategy. But the lead prosecutor in the case, Bill Wakarski, brought up the possibility of the agreement a number of times, well before the agreement was discussed in detail and eventually reached. Huh? So he brought it up. He proposed it to you 1,000,001 times. How was he talking to you so much? Because y'all shouldn't be in that close communication unless you're brokering plea agreements, unless you're, I'm sending you this email. Here's this package for discovery, what have you. This is making it sound like they were buddy at the golf club talking.
It was
co-conspirators.
How many of us have them? They
co-conspirators.
Rico's on the phone, Jonesing on the phone, some Love Jones business.
This is why you don't trust prosecutors or
setting this boy up. That's
a fact, though.
Well, here's the easier thing, and I know a lot of people get mad when I say this. I was just talking about this on Hamps. If you know that you don't trust the prosecutor or the defense attorney, then don't do what you got to do to end up in the system. But anyway, let's continue.
Right. Okay.
You're right.
Right. So now this is, if this is true, because if it's the case, then he's going to have to, potentially, I don't know, the appellate court might just dismiss his whole affidavit, right? But if they take it seriously, he's going to have to substantiate it. He's going to have to produce call logs. He's going to have to produce call recordings. He's going to have to produce evidence that they were in the same place at the same time when they shouldn't have been, or, what have you. So when mentioning a proposed agreement, Wakarski proposed that we try the case clean, which he defined as based only on what happened under the tent that day. So if you're brokering a deal, it's not based off of what one person defines. In law, contractual law is based on the meeting of the mind. So this is a one-sided contract. So off the gate, he's saying he wasn't operating in the best interest of Karmelo Anthony, right? Not going to character, reputation, blah, blah, blah. On May 5th, Mr. Shook and Wakarski discussed this proposed agreement by phone. So now this is hearsay.
Absolutely.
You're not talking about what you discussed with Wakarski. You're talking about what Shook discussed with Wakarski. What evidence do you have of this? Do you have a recording? Were you a party to the room? Does Wakarski have a deposition up in here? Mm-hmm.
No, all we have is that, remember, a third-party witness who is the judge, because all of the things that we're speaking about, we're going in front of the judge and speaking to him multiple times. He is a person as well.
Uda, deal with Uda, deal with what she's saying. On May 5th, Mr. Shook and Mr. Worse
telephone love
discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Worse discussed the evidence of character, reputation, and extraneous offense/bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Worse reiterated that he would be happy to try this without getting into character at all, just on what happened the day of the track meet.
Well, let me ask you a question.
Wait. Let me say this right quick. That's hearsay, and I'm gonna tell you why.
It's not.
Wait, hold on. Wait, let me.
That's what I was about to tell you. It's not. He's co-counsel. He's co-counsel. It's not hearsay.
Is there a record of this? Is there a recording?
He's co-counsel, so it
is
probably
there a
is.
Recording.
It's not hearsay because he's co-counsel. He's co-counsel.
Well, here's the problem. Listen to the question I'm asking you. Is there a recording?
Yes, probably so. Didn't you say, Raw, that when lawyers get on the phone and in order to bill their client for billable hours, that they automatically record for so that they can have record for their proper billing?
Got you. Right. Now, was this preserved in evidence during trial?
No, that's
my point.
No, I get that, but what I'm saying is it's not hearsay because he's co-counsel, bro. That's not hearsay.
Go ahead, baby. Read.
So the point that I was getting to, because y'all just do whatever the hell y'all want to do while I'm trying to make a point, but I appreciate y'all. You know, y'all adorable or whatever. The point is, it's hearsay because as I'm looking through the exhibits, I don't see an exhibit from Tony Shook. They have transcriptions of certain calls. They don't have a transcription of that call, right? So when we're talking about the evidentiary element of this case, it's not substantiated. So this is, as Studio Mansion has been saying all day, a case of fan fiction at this point. And I'm just double checking while I'm, talking to y'all and killing a little time and making sure in the exhibits there's not one from Tony Shook.
Right.
It's not substantiated is the ultimate. It's the ultimate point because there's a bunch of pages that are Mike Howard. And it's too much for us to read all tonight, but I'm gonna continue. There is no affidavit from Shook from what I can see at this point. And I'm just looking at Exhibit 9. Nope. And everything else is about the PIO or whatever, POI, whatever. Okay, so this section right here, section 4, is going to be contended against. It's not substantiated. Now, on part 5, right. If it's not recorded and it will never happen, it won't be considered. Facts. Okay, so on May 8th, the defense and prosecution teams met in the Collin County grand jury room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses. So on May 5th, y'all had a conversation that y'all weren't going to talk about extraneous offenses. But on May 8th, you were given a document entitled the State's Notice of Intent to Use Extraneous Offenses, but y'all brokered a deal, right? And we gave them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule and evidence under Texas Code Criminal Procedures Article 38.36, hereinafter the defense notice. After tendering to each other our respective extraneous filings briefings, we then discussed the proposed agreement, which Mr. Rikursky referred to as a gentleman's agreement. A gentleman's agreement is not a motion of limine. So, Uda, when you're saying they filed a motion of limine, no. Howard was proposing to file a motion of limine regarding the admissibility of certain evidence. The state never was. There was not a motion of limine filed according to this affidavit.
Okay, but no. But you got to go down and you're going to see, because that's what they agreed. They agreed that the defense would do that. So that was their own agreement, right? So also besides that, it's not hearsay because both attorneys are figuring out the parameters of how they're going to do within a trial. So it's not hearsay. It's not a hearsay thing. And then they're going before the judge as well, right?
Well,
this is their agreement. That was their agreement for the defense to do that in limine and all of that. That was their agreement. That's
but
what
Uda, let me ask you this question. Go ahead, babe. Go ahead, babe.
No, go ahead.
So, Uda, let me ask you this question, because you said as you read further down, up until this point, would you say it's hearsay if there's no evidence? There's nothing substantiable up until this point. I'm just asking so far.
All right, look now. Let me break this down. Here's why. Hearsay is out of court statements offered to prove the truth of what a statement asserts. When the attorneys are negotiating how a trial will proceed, agreeing on evidentiary limits, discussing motions in limine, or proposing procedures, they are typically not making statements to prove the truth of facts in the case. They are negotiating procedural matters. So if those negotiators are later offered in court to show that an agreement existed, rather than to prove the truth of some factual assertion, then this generally isn't hearsay for that purpose.
Yeah, but that's arguing to a point, especially if you position the point that this would not be considered hearsay. But the problem is you can't use an LLM to perceive law. LLM is not human. And I'm saying LLM for a reason, because that statement that you just read does not come from a human being. So I'm asking you, per everything that we've read up until this point, if you do not see in the record, in the trial record, in the evidentiary record, you don't see anything mentioning this gentleman's agreement, would you say it's hearsay? You're telling me something that you can't prove, you can't put in my hands, I can't listen to. Would you say it's hearsay?
Nah, because they both are just negotiating the facts. They're negotiating how they want to run the trial. So it's not like
okay. So here's the thing. I'm gonna make it really clear.
Yeah.
I'm gonna step in my patience back. So this is from the Federal Rule of Evidence, right? From Columbia.edu. These are the laws. These are the laws in regards to evidence, right? Hearsay rule. Hearsay is not admissible except as provided by the rules or by other rules prescribed by the Supreme Court pursuant to the statutory authority or by acts of Congress. Hearsay exceptions: availability of declarant immaterial, present sense impression, excited utterance, then existing mental, emotional, or physical condition, statements of purpose, recorded recollection, records of regularly conducted activity, so on and so forth, right? How absence of entry in records kept in accordance with the provisions of paragraph, evidence that a matter is not included in the memorandum, reports, records, data, complications in any form kept in accordance with the provisions of paragraph 6 to prove the non-occurrence or non-existence of the matter. To prove, keyword, prove the non-occurrence or non-existence of the matter. If the matter was a kind of which a memorandum, report, record, or data compilation was regularly made and preserved, unless the sources of information or other circumstances indicate lack of trustworthiness. Now, that's very important when we get down to the requirement of authentication or identification.
Come on now.
You have to require the requirement of authentication or identification as a condition precedent to admissibility is stated by evidence sufficient to support a finding that the matter in question is what its proponent claims. You have to have substantive evidence for the claims being made in this affidavit. And if he does not have anything to substantiate this, which he absolutely cannot for point 4, because this is a third party recollection. This is not even a direct recollection. He's recalling what happened between Mr. Shook and Mr. Worskowski, and that could have been reported to him from Mr. Shook because in the exhibits, it's not here.
Yeah, there's no record of it.
No,
it's no record.
Remember, you know why it's not there? Because remember, the judge he had no mechanism to enforce this thing, though.
Yes.
Also told him that, so you have to factor that part into as well.
No. I know.
Okay, wait, because I think we're making some headway. So
right?
Just ride the train with me. Ride the train with me. Now, this is a highly venerated lawyer, Mike Howard, right? So he is trying to save face and maintain reputational integrity. He's now spinning a narrative that can't be proven in order to make the case better for his client that he just lost a very public national case on. Does he have modus operandi in order to give an inauthentic affidavit or deposition in this case? Absolutely
not.
He has motive. So how he is defining it, right? How he's uttering what happened. If it was a gentleman's agreement is something where you just shake a hand.
Like a handshake deal.
Yeah, it's not enforceable from the get-go. So he's a lawyer. One thing lawyers really understand is if it's not written, it doesn't matter. So he's sitting here giving a narrative that this is what we discussed, but there is no documentation. In order for this affidavit for me to have any substantive value, there would have to be an email chain. There would have to be some phone logs, even if he didn't record the calls, right? Even let's just say for shits and giggles, they were just talking on the cell phone. It would have to be some phone records of when Shook talked to Wachowski, when he talked to Wachowski. There would have to be some receipts. We were at the country club, at the golf course, something. There is none of that in the exhibits. So this affidavit is not going to matter.
Yeah, it falls on his face.
But look what I'm saying. There's one thing though. One thing, right, Sal? So look what I'm saying here, right? Because I want to be able to explain it the right way, right? So I just want to read this thing to you, right? So this says so let me get the mic right. But I said, look, it says the judge's statement that he had. We're gonna go to him having no mechanism to enforce it, right? So they said the judge's statement that he had no mechanism to enforce the agreement is also significant, right? But it doesn't automatically make the conversations hearsay. It just suggests that the judge may not have the judge may have viewed the agreement as one between parties rather than a court order. So whether such an agreement could later be enforced or whether a breach just justifies a new trial, it just depends on the governing of law and the specific facts. So if the defense is arguing for a new trial, the argument is likely to sound more like this, right? Which we're at here. The state agreed to X, the defense relied on that agreement, and because of that reliance, Karmelo did not testify or made other strategic decisions. That agreement was not honored or the defendant's rights were affected. So therefore, thus, here we at where they're asking for a new trial based on this and the other parameters that they're asking for. See what I'm saying?
Let me ask you a question. Where are you reading that from?
You can put in a back chat. Everybody don't need to be in your business.
No. And that's I want him to answer in the back, but this is why I got into that big ass argument with a lot of people last year.
Okay.
1 second, y'all. Oh shit.
What is you eating?
I'm not eating anything. No, I ain't eating nothing. I accidentally just bit the shit out of my cheek and I got blood in my mouth.
Man, that's the worst
feeling
ever, bro. That's the worst feeling ever. Swear to God.
All right, so what I was saying was that when we're dealing with the court of law, we have to look within there is a way. I just never told nobody. There is a way within the law that Karmelo Anthony walks away innocent. I'm just not telling nobody because I want people to go read. It's literally right there. As a matter of fact, multiple people have scanned over it because they focused on 931, 932. There's actually a statute that gets Karmelo off. I just never told nobody. The problem is this: when we are looking at what is being presented in this affidavit, which I appreciate y'all bringing this conversation, and I do need to go back and watch that stream you did yesterday, Izzy. Excuse me. The problem is everything that he's saying in this affidavit, if there's nothing to back it up, it's hearsay. You have no way to substantiate your argument. You have no way to back it. You have no supporting fact. You don't have nothing.
I agree in some ways to that. I agree because it was even the judge couldn't enforce it as well. So I do
exactly.
Agree with some of those things.
So here's the thing. Hey, Uda, watch this. So if I don't have a way to enforce a thing that y'all so-called agreed on, guess what can happen if you put Karmelo on the stand? Which I'm glad I went back and I found this, right?
They would have shredded him.
Exactly. And the prosecution had every right.
That was the point, Sel, but that was the whole point right there. That's what we've been saying the whole time.
Right.
And that's why he didn't testify ultimately.
So now walk with me on this. Walk with me. The defense brokered a bad deal for his client.
Allegedly.
Facts. Allegedly facts.
Allegedly, the defense brokered a bad deal for his client. And when it came time for an opportunity for his client to actually give face to his perspective, not face, give motion to his perspective so that people can hear from him, Karmelo Anthony decided that the best thing for me to do, because I only got 10 minutes to decide, I got 10 minutes to decide the next X amount of years of my life. Karmelo Anthony chose not to take the stand. based on bad counsel, which that bad counsel brokered a bad deal. Bad deals and bad counsel, you can go look it up. That percentage of you getting a retrial is less than 5%. And I'm being gracious by saying less than 5%. But you don't get a retrial based on that.
Right, but now when you compile it with the fact that they didn't give the jury proper instructions on this situation, when you compile it with the fact that the evidence wasn't properly admitted and it was excluded, you know what I'm saying? When you because this is a whole nother thing. How the hell did they bring a replica of the knife and not the actual knife? Like, yo, it's so many things. I'm not a lawyer, right? But it's so many things that common sense wise, I can't see how it could be legal or it could even make sense. They didn't even bring the actual weapon. They brought a replica of the weapon. They sped through the trial and tried to make a speedy trial. That's not constitutionally sound. They didn't give the jury proper instructions as to how they were supposed to view this case. They didn't even give allowance for the fact that it could be self-defense and how it could be self-defense. It was a shit show all the way around, bro. That's the point. So I don't like I said, I don't think Karmelo's innocent. My thing is give the man a fair trial and a proper defense. That's it. And whatever the number lands on, I'm good with that.
Does he speak anywhere in this affidavit about the jury instruction? Because I just controlled F and I don't see nothing in here other than the jury instruction that was submitted.
Well, the appeals, he's not an appellate attorney, but the appellate attorneys absolutely have that in the briefing.
But hold on, wait. This is my problem. You're saying in the affidavit, yeah, the jury instructions was bad. Okay, show us your proof. Well, I don't have it.
No, well, they're gonna provide. I think they did provide that, right, Uda?
No.
I'm looking.
No, it's you gotta remember it's 193 page.
Yeah.
You know what I'm saying? So yeah,
I got the whole entire document right here.
Yeah, we got a
What I did.
I'm
gonna let y'all have it because
go ahead, baby. Go ahead.
I just saying they had a whole section for that. That's what I was saying.
I know y'all being masculine. Y'all being masculine. I'm trying to be feminine, my soft girl era. No, but here's the thing. I skipped through to the exhibits. There is no exhibit from Shook. There is no exhibits of transcriptions of phone calls. There is no exhibits of call logs. No, nothing. No. And this is only substantiated by this affidavit. So, as I stated earlier, because I did just do some research, y'all know I'm in school and doing some law shit right now too. Well, so I knew I was right. You know what I'm saying? That's why I'm on the president's list. But it says, this is sworn testimony, but much of the most explosive material still depends on the credibility of counsel and needs corroboration at an evidentiary hearing. He's going to have to corroborate this. And it's not corroborated, corroborated, whatever. My mouth is tired. I've been talking all day. It's not corroborated in this appeal. It's not. That's going to be a big problem for him.
Yeah. But, but this is just one fact. You know what I'm saying? Remember, his testimony is only one part of the compounding evidence that they're going for. So remember, like I was telling you about the about the 4 Waller points that was broken, when they go into those things, when they go into how he started with the overflow rooms in the very beginning and pulled them right before the trial or the testimonial part of the trial began. He got so many other factors, plus those things. So it's a whole bunch of factors. So it's just not, they're just not relying just on Mike Howard's affidavit. Is other factors that they're also using to kind of compile, and then they cite in these cases, which is Stricker, Lilly, and the other cases that they're also citing. And in those cases, is based on, forget Mike affidavit, based on the cases that they're citing, just people being excluded from just being in the courtroom and different things like that, people received new trials. So it's so many different little layers that any one of these factors could be a reason that they could possibly get a new trial. Even if the Mike the Mike Howard thing don't fly. They still got other little factors that they're pushing for that could give them a good chance to get it. You know what I mean?
Right. So, and I hear you, but while you did bring up Waller, there are cases where that a suppression tactic has been upheld, like Gannett versus De Pascali. And then we also have to take into consideration the judiciary history of that particular court. In Texas, Collin County courts have suppression hearings, motions in limine, and all that is very common. It's very common there. So using that as a basis for reversal, it may not really work. What that's going to do is it's going to make the appellate judge say, well, did he make a good call or did he make a bad call? And historically, appellate court judges uphold the calls that the trial judge has made. They do.
I agree with that, Raw. I agree with you there. They usually do, and they usually want to stick by what the jury did. That's a fact as well. You know what I'm saying? So it's going to take a lot for them to want to overturn it. You know what I mean? You're going to have to come up with some firepower to make them do it, because usually they're not in a rush to come and turn over. They really want to stand by what the jury's verdict is and the way the judge handled the case. So that's their first option or their first inclination to do that. So they're going to have to make a strong case, which I see they have some good factors that could be a possibility that could be for them. You know what I mean? But it's going to be uphill climb for them. It's going to be uphill climb for them.
Yeah, I'm on 73 out of 143 times that the word jury was mentioned in his affidavit. I'm appreciative of him filing the affidavit because that gives a little more insight from his perspective. But the key things that I have researched on appeal cases that have worked, I don't see it in this affidavit. I just don't. It's quite a few things that you have to
on the record. When you find them with appeals, it's usually going to be things that's on the record, things that's brought before the judge. It's usually going to be those types of things. So that's why I think that the defense was really lackluster. That's why I was saying before I even read this, because usually when you go in appeals, like all your objections, all your motions, all the things, you do it on the record. You usually do these things all on the record, and this is how it helps you in your appeal. A lot of things were not done on the record.
But watch this though. Hey, Uda, watch this. Go talk to any lawyer and ask them, is it possible to win on appeal or get a retrial based off bad counsel? The majority of them will tell you no. They will. Yeah. So him filing this affidavit is, and I'm not trying to say this to, taint the filing of the affidavit, but this is just him whining and complaining about why he didn't win. That's it. That's all this affidavit is. There's nothing in this affidavit that would say, hey, we need to take a second look at this. This is just me crying. This is him crying over spilled milk. And he's the one that kicked the table.
Yeah.
He accepted the glass.
Him being incompetent, more likely.
Absolutely. Absolutely. Yeah. But the problem is this. That now falls back on the person who hired him or the people who hired him. And they can't blame Charleston White, even though Charleston White was like, yeah, I'm the one that told him to go hire the white boy. You can't blame Charleston. You spent your money. You signed on the dotted line. No one made you do that. Right? Really quick, y'all, because it is 10:41, and y'all know I got homework that I got to get done.
Right. I was about to cut you out. No, I wasn't about to cut you out, but I was about to remind you we got things to do, sir.
I love you,
Jason. Appreciate you. Love you too.
No doubt. Salute. Much love, man. Dope build, dope discussion. Hey, yo, I like being able to build and discuss where people don't be taking the shit personal or feeling like, we got to attack each other because we disagree. You know what I'm talking about?
That's the way.
Yeah, exactly. You know what? I posit that we need to bring back, regular ass conversations in these spaces, because no matter what the topic is, you don't ever have to see eye to eye with anybody, but you can always operate out of respect and just substantiate your argument. Real talk, real spill.
Agreed.
Well, we need to have more conversations like this, but the biggest problem is us four as content creators, we understand that position and the value of that conversation. You know what the problem is, though? You have other content creators who need to make the conversation about them, and that's where it goes left. When you make the conversation,
My bad. That my bad. I'm listening.
you over there dancing, man?
Nah, I pulled the cell mistakenly, but I'm listening. When they make it about themselves, I'm listening. My bad.
Oh, for real, motherfucker.
I'm listening. I'm listening. My bad. Go ahead.
Nah, that's my final words. Y'all give y'all final words because I got to get to this homework. I got very important homework.
Nah, God bless. Good night. Peace, y'all.
Appreciate
Peace,
it.
Izzy.
Salute Raw, salute Self, salute the chat, man. Salute to everybody, man. Great conversation, and I love it, man. I love what this is discussed. And that's just a blessing, man. You know, that's it. Salute to y'all, man. Do it again.
Hey, what you over there eating on?
Right.
I made some chicken, rice, coleslaw, pasta salad, macaroni salad. I made everything, bro. I'm a chef on the low. That's life.
Sounds good. Sounds good.
So he said all that good food. He ain't shipping the plate. He ain't sending the DoorDash.
I'm gonna send it FedEx. I mean, I would send it with Mike Howard, but you won't get it. It'll be handspray, bro. But I'm gonna send it. It'll be handspray. Shout out to y'all, yo.
Take it easy.
That is funny as ever. Okay,
Jesus
let me hear my final words.
Go
This
ahead.
case is the gift that keeps on giving, unfortunately. And you know, the real tragedy here is that a young man's life is in the ballast. And it's quite unfortunate if what Mike Howard said is, you know, what his affidavit affirms, if that is true, because that means that that is the greatest miscarriage of justice. And again, I stand hard body on where were these attorneys when he was going through the guilt innocence phase. They should have been there to really have his back. A lot of activist groups really failed this young man. But if he gets a new trial, please bear in mind that the prosecution can also add more charges.
Sure can.
As well. So this is gonna be interesting to watch. Thank you guys for joining us tonight on Self-reliance Podcast. My Chaos Brew. I believe Uda simulcasted and possibly Izzy too, wherever you watch today. Thank you so much. And have a good night.
Y'all take it easy. I appreciate y'all stopping by. Thank you to everyone who supported the show by way of Cash App. Greatly appreciate that. With that being said, I'm gonna give y'all a little outro music and y'all go ahead and enjoy y'all night.
There's no music, sir. Is he ignoring me, child? He is
You said what, baby?
There ain't no music playing here.
Oh, it ain't no music playing? Oh, my bad, y'all. Hold on. My bad, y'all. Hold on. That's that. You know what? I accept responsibility for that. Excuse me.
Yeah. Lord have mercy. Y'all done lost your minds now. They call them watermelon felon. Everybody yelling. Keyboard gang swelling. Comment section dwelling. Watermelon felon. Everybody telling. Half the folks just laughing, other half rebelling. Watermelon felon. Name ring like a bell. Funny how a nickname got the whole world yelling. Facebook got the lawyers and the judges, everybody holding grudges, everybody know the facts, till you ask them for the sources, and they mumbling. TikTok got the experts, YouTube got the sermons, everybody got opinions, but ain't nobody working, means flying faster than the truth. Everybody acting bulletproof, one side screaming, lock him up, other side screaming, free the youth, they call him watermelon felon. Everybody yelling, calling section tragedy turned into compelling. Some folks laughing, some folks crying, some folks posting, some folks lying. Everybody picking teams, everybody chasing dreams, everybody want attention, everybody want the streams. And if outrage paid in dollars, half these folks would all be scholars, sitting on the internet acting like they wearing collars. Yesterday they loved you, tomorrow they'll forget. Today's outreach champion is next week's biggest bet. People change the story every single day, but one thing stays the same. Everybody got something to say. Watermelon felon, everybody yelling. Country boys and city folks all up in their feelings. Watermelon felon, name they keep on spelling. 20 years from now, they still gonna be telling. Watermelon felon. Yeah, they yelling. Lord have mercy. Y'all done lost your minds.